Leave to move this appeal matter without certified copy.
Why, sir? Why without certified copy?
But it has been applied for the certified copy, but it due to the pituitary.
So let it come.
If you
Let it
lordship
come,
kindly
let it
allow
file.
me. But despite being acquitted from the departmental proceeding, my salary and pensions, everything has been.
So that is
Your
nothing.
lordship kindly.
Nothing will happen. You wait.
Grateful, my lord. Another one is, my lord, I'm praying for inclusion of hearing matter.
If inclusion, you may give. Whichever, if you want inclusion, you give. Motion. Monthly list. Monthly list, all included.
Yeah, we have committee inclusion, my lord.
All.
Let me clear. No, the copy has been served, they are received, but affidavit service that will happen today. Yes, I got the tag report. Originally, the applicant has died. She has died. After the order was passed by the tribunal, my lord, the tribunal dismissed the applicant on the only solely on the ground of delay. But she was dismissed from service, my lord, in the year 2012, but that was not informed to the applicant. Applicant came to know after making application under the Right to Information Act 2018. You will also kindly see page 23. First, we also can see the impugned order. The matter is taken as a single judge, single bench, pursuant to the sergeant sir. Let abuse service kept on the record. In this application, the applicant has paid for setting aside the order of dismissal of the applicant passed with the respondent final order dated 2011. 2011. The medical superintendent come principal such and such, a female GDO from service. The tribunal finds this application barred by limitation for challenging the order before this tribunal. But you also can see paragraph 20 we have mentioned, the first one 23. Page 1 17 November, page 22, the 23. 22, my lord. That's a dated 17 November 2018. That was written by the medical superintendent come principal to the petitioner. Pratimada, petitioner. As per our office record, it refers that you have been removed from service with effect on 29 July 2011. Xerox copy of the office memo such and such are enclosed herewith. But that order, next page 23. The removal order passed by the discipline authority dated 29 July 2011. Whereas Srimati Pratima Das, XGD, was issued charge sheet under this memo number such and such dated 22nd July 2011, giving 7 days time on receipt of this order, submitting the written statement of defense and also stating whether the desire to be heard in person. Whereas Srimati Das did neither submit written statement of defense nor appear in person only on consecutive days or 12 July 2011 and 19 July 2011 in order for ex parte decisions taken by the inquiring authority. Whereas the Srimati Das is in the habit of taking leave without prior permission, in every case, is the article of charges to her fame for her frequent and unauthorized absence.
What is the date? What is the date of P5? What is the date?
T5, page 23.
Huh? What is the date of P5?
Oh, well, that is 29 July 2011. But it has been mentioned, page 22. They have said that medical superintendent for the first time sent to the Pratima Das. Because the Pratima Das, my lord, the petitioner, the applicant, my lord, they filed an application under the Right to Information Act, claiming pension. His actual date, her actual date of determination on 30th June 2012.
30th?
30th June 2012. Since she did not get any retirement benefits, she made an appeal. She went to the office of the medical superintendent from principal. With the finding no authority, they filed an application for under the Right to Information Act.
And she filed the OA in 24.
Yes, my lord.
12 years after her date of retirement, she filed the OA.
Yes, because only your lord came to know in the
18.
that was 18.
Yes, and she
That-
filed in 24. And she
That-
filed the OA in 24.
24. There are prior to that filed an application, the seventh application, last representation that was made, the demand notice, because in the middle there's a corona period also. So this also page 31. Demanded to the lawyer on 18 January 2024.
Page?
18 January 2024.
Where is that?
Page 31. And the facts remain the in all application, Potibada was informed. She was not even informed
Yes.
about the date of dismissal and the proceeding.
Yes.
If you look at the pleading, there are 2020, my lord. Yeah, the copy part. We got hard. But learned judge Wala did not only the application has been filed after long days, that is the dismiss. But page 28, my lord, you are saying anything? The medical superintendent, he has also sent a letter to the appellate authority. He made appeal to the appellate authority also. That was on 20th September 2019. Same plea, he has dismissed from service. This is a disciplinary proceeding in that. On my submission before lawsuit, she has not even, they could not produce, they can, whether she received the copy of that notice.
My lord, I am
That's all.
for the state. I am praying for not today.
Yes, take it down. Heard, Leonard.
Item number 3.
Item 3, my lord, I appeal for the petitioner. The matter is resignation of a doctor, my lord, where the tribunal passed an order in my favor. Thereafter, I have complained to file a contempt petition there. My lord, because of non-functioning of the tribunal, I have to approach your lordship.
Still not received, still not,
Your lordship will the
Let me take instruct. I've just got the brief, lordship. Let me take
parent
instruct.
order 71.
was paid by learned AGP.
দশ তারিখ 10th August.
Item number 4.
Or I'm appearing for the petitioner, my lord, led by Miss Dash. My lord, she couldn't attend the court due to some personal grounds.
Not today.
My lord, not today.
My lord, kindly take it up then next week, my lord.
Why, sir?
I'm ready today, my lord, but
Let it come tomorrow.
Okay.
Item number 5.
Well, at item 5, I appear for the petitioner. This is restoration. This is my affidavit of service.
Chip, I'm appearing for the state with shipwreck.
It was dismissed when we missed the list on that emirate and paragraph 4 malad.
And what is it on merits?
On merit malad, I'll come later on.
Later.
I'm not ready with the merit.
Which paragraph? You have given the reason?
Well, at page paragraph 4. Malad, we missed the list.
It's transferred.
An application for restoration.
Dosh.
In the meantime, you get the copy and
I-
everything else.
I've got the copy. Now,
Item number 6.
Well, at 6-7, I'm for the petition. I'm led by Mr. Kolal Basu. Well, at on the last occasion, please to adjourn the matter to enable
yes,
my
lordship,
learned
I have,
significant to take instruction.
Regarding?
lordship, this is regarding, lordship, on the last occasion, lordship said there was,
Counting of past service that the
Memo-
petitioner has discharged in the Chittoranjan Cancer Hospital.
lordship,
as
there was a
case
particular
management doctor.
memo where the government had, the matter was referred to the place of employment of the petitioner, that is the JB Rai Ayurvedic. Lordship, we have also approached them after your lordship's order. Lordship, they've asked for a fortnight's time, lordship, to get all things sorted out.
As your lordship is.
Yes. For the fortnight is
Lordship. Doctor.
10th August.
ছয় সাত করে দাও। তারপরে আমাদের করতে হচ্ছে
Item number 9.
But I'm appealing for the. Lord, I should be fair enough in submitting. On the last occasion, my lord, my learned friend on the other side appeared and took a point. Yeah. My learned friend, my lord, on the other side took a point
For the state, my lord.
that, my lord, previously, my lord, we have, my lord, challenged the order of dismissal by the authority, my lord, in my lord, original proceeding as well as, my lord, which travelled up to High Court and it was affirmed. Now, my lord, that's true. The fact is true. Now, my lord, only thing, my lord, I would submit, my lord, there is a change of circumstances which has occurred. Now, my lord, what happened, my lord? My lord, when the 4 counts of charges, my lord, which were framed against, my lord, the charge sheeted officer, my lord, is purely based on, my lord, an issue, my lord, where I have, my lord, concealed, my lord, certain facts, my lord, and has played fraud upon the, my lord, appointing authority, my lord, at the time when I was being appointed as the constable. Now, my lord, what was the, my lord, nature of the charge, my lord? That I was somebody, my lord, in working in CRPF, and, my lord, I have manipulated the date of birth. Now, my lord, in these two, my lord, circumstances, 4 charges were framed. My lord, they lodged an FIR. Now, my lord, without even going to, my lord, merits for the moment, my lord, what happened, my lord, in the FIR which culminated into criminal trial, my lord, exonerated me, saying that they have, prosecution has failed to prove, and, my lord, the criminal trial court has recorded the commandant of the CRPF, on the basis of which of their framing the FIR. My lord, the commandant himself has deposed that he has not issued any letter. And, my lord, the CRPF is not in a position to say whether this person is, my lord, the same person who is being, my lord, now dismissed. Now, my lord, in that circumstances, this trial, my lord, ended in 2025. Now, my lord, after the trial ended, my lord, I made a representation, my lord, before the my appointing authority, my lord, which was treated to be an appeal, and, my lord, which was dismissed in, my lord, 2024. Now, my lord, in 2025. Now, my lord, that order, my lord, was assailed in before the original tribunal in the second time.
Where is that order?
Yes, my lord, kindly. Kindly turns to page 77 of the, my lord, writ petition. Yes, my lord, annexure G. Appellate order, my lord. What has got that?
That is page 102.
And I'm sorry, my lord. Info, sir. Arbiter brief, page 1024. Annexure G. Wait a minute. The original dismissal order. My lord, that is, my lord will find annexure D. পেজটা বলতো আমার এখানে প্যাজিনেশনটা গন্ডগোল হচ্ছে। annexure D টা dated 30th of October 2000, 2000 ডেটটা বল 2008, 24th of July 2008 order. Annexure D. আমার এখানে প্যাজিনেশনটা জজের সাথে গন্ডগোল হচ্ছে, আর স্ক্যান কপিতে প্যাজিনেশনটা গন্ডগোল হচ্ছে। আমার এখানে এই পেজ নাম্বার গুলো আসছে, এইগুলো এইগুলো আসছে। হুম? এটা বার করছি ক্রিমিনাল কোর্টের জাজমেন্ট, ক্রিমিনাল কোর্ট। শুধু গিলটি দেখে ফাইন্ডিংস গুলো দেখাতে হবে, আমার এই চার্জের সাথে এক ধরনের।
Is OR, O/R?
But original records, most probably, because this is what the abbreviation, I could relate to.
Perhaps not. The CO was heard in his OR. The charged officer was heard in his original register cannot be.
Orderly.
Orderly room.
Orderly room. Oh.
That is maybe a form of proceeding under the CRPF Act and rules.
Well.
Perhaps. As they have SSFC, as they have SSFC in some of the provisions, something like that. OR.
Maybe, my lord.
What is OR?
Orderly room. OR is
It
orderly.
is a proceeding. Yes.
Yes. Milord, first, Milord, I should come out of the Milord point of maintainability. Milord, I respectfully submit, Milord, yes, Milord, initially this order, Milord, at D came up before Honorable this court, High Court, and Milord, it was affirmed. Now, Milord, what happened, Milord, after the criminal trial, Milord, acquitted me.
No. So substantial point today is whether you can get benefit of the acquittal or not. That is all.
Absolutely.
So
Milord.
tell us.
Yes. Now, Milord, if my Lord, then my Lord kindly turns to the criminal court's order, Milord, because I will be relating this to.
Yes.
Nothing more. Now, my Lord, kindly turns to criminal court page number.
Page 72.
What is the date of filing of the original application?
My Lord, original before this tribunal.
Yes.
Just a second. This was filed in 2025. Right, so. Wait. নতুন টাই 2025 exact date of affirmation.
No, we need the exact date.
Exact date. That to পেছনে affirmation. Because they have annex order sheet annex করেছে. Order sheet last order sheet 21st of May 2025.
From where can we get
That kindly turns to page 43. Yes, and my lord, page 100. First order of the tribunal which was passed is on June. Order number 1, which is a part of annexure.
21st May 25? That's his verification. Very well. You proceed.
Now, my lord, if my lord turns to the order passed by the criminal court.
Yes.
Page 68. Now, my lord,
verification role not produced, no ocular evidence.
Yes, my lord, this is one thing. My lord, this is in the my lord proceeding also. My lord, the commandant, my lord, on the basis of whose letter, my lord, the entire thing started. Now, my lord, the commandant himself deposed that I have not issued that letter. Now, my lord, now if in the criminal my entire submission would be the same, my lord, charges, my lord, was converted into an FIR. And the criminal court proceeded on the similar, my lord, point. My lord, there is no distinction. My lord, not even I would say same, not similar. Now, my lord, if same, my lord, charges were in an FIR, now, my lord, only thing added was it was fraud, for which FIR was, my lord, done. And my lord, criminal court, my lord, has categorically on deposition of the same witness.
Which witness?
My lord, who were deposing before the.
Here is it shows which witness.
Finally. Well, kindly turns to internal page 7 of the criminal court's judgment. First, my lord.
7.
Yes, first, my lord, what was the point for determination by the criminal court? That would be relevant.
No, let us see who has deposed before the criminal court.
Very well, my lord. My lord, kindly see paragraph 15 of the judgment.
Yes. Paragraph 15 is at which page of the
page?
judgment?
Internal page 8, and the running page of this petition is page number 75.
75, yes.
Starts. Milord, PW1 Nojrul Islam. Milord, the same person was in the proceeding because out of Nojrul Islam's Milord initiation, Milord, the disciplinary proceeding was started and he was a witness there. This is one, Milord. তুই চার্জশিটটা খুলতো, চার্জের ইয়েটা খুলতো, ডিসিপ্লিনারি প্রসিডিংটা শুভ্রাশীল সাক্ষী দিয়েছে কিনা দেখ। আচ্ছা, শুভ্রাশীল ডক্টর নাম পিডব্লিউডি সৌমেন্দ্রনাথ মন্ডল, সৌমেন্দ্র মন্ডল, আলম, তারপরে জয়দেব সরকার আছে না, দেখতে হবে না। সুখেন্দু শেখর পাল, সুখেন্দু শেখর পাল নামটা দেখলাম। সুখেন্দু পাল, লোক 6 আছে, নজরুল ইসলাম আছে, এস আলম আছে, PW6, এস আলম, PW3, টিক কর। The same exhibits were there. I mean, similar exhibits have come in, which were before the disciplinary authority. Now, my lord, I can only relate, my lord, the witness of the, my lord, কি বলে, the disciplinary authority who were there in the proceeding at page 47, Nazrul Islam, SS Alam, my lord, page 47.
That is not relevant. There are two findings of the criminal court.
Yes, now, my lord, it is also.
First finding is that VR form was not produced.
Yes.
There is no ocular evidence in support of the fact that he, in connivance with someone, has manipulated his date of birth. That is the first finding. The second finding is that the IO did not collect from the CRPF the judicial trial conducted in leading to his imprisonment for a month or whatever.
Apart from that, there is another,
These are the two.
another finding in both
Yes.
the Milord cases.
Let's see which is the other finding apart from these two findings,
Yes.
based on which the acquittal has been recorded.
Yes. Milord,
you see paragraph 34, it says there are two informations which forms the basis of the entire proceeding.
Yes.
Both the information the trial court rejected on these two grounds. If there is something else, please show us.
yes. Just a minute.
So the question, if there is nothing else, even if there is nothing else, an issue which still would arise is whether the VR form was considered therein or not. And the second is the factum of his release from the CRPF or his imprisonment for 30 days, whether it was supported by any evidence on the preponderance of probability in the inquiry or not.
Yes.
This is the only thing. So let us see
Yes.
both these aspects.
Yes. Now, my lord, kindly Milord turns to Milord internal page 10, Milord, as because the date of the criminal case record.
Why?
Because same exhibit was there, Milord.
That's immaterial.
Achha, very well. Milord, I go to the disciplinary.
Need not go into all what has. This is the conclusion of the court in paragraph 34, 35. It records its reason for not holding the charges proved. It says there is no material in support of this allegation that you, in connivance with someone, has manipulated your date of birth. And the other is that you did not bring any material to show that you were awarded a punishment of 30-day imprisonment and it was held that you will not be fit for any further appointment or no. So these are the two grounds on which it appears the acquittal has been recorded, unless there is something else. You said there is something else, but we have not seen anything else.
Lord, kindly turns to then, my lord, page 24 of PW9 is Jayadakol. The evidence of PW7 and PW9, which were before the disciplinary proceeding, my lord, which was absolutely overlooked, my lord, in my respectful humble submission.
No, that's not the point. See, there is no scope for going into practice of the finding of the disciplinary authority inquiry officer. That is a sealed issue. It cannot be looked into again.
Absolutely. Reappreciation,
It cannot be considered again by any standards.
if there is two opinion can be formed, one opinion if taken, my lord, in
That stage is over. That is over in the earlier proceeding. Now that is not open to scrutiny in the present proceeding. We cannot reimburse.
there are two things I will submit.
We will only have to see whether these two reasons for your acquittal in the criminal trial are apparent from the proceeding in the inquiry or not.
Yes, that's why I say, my lord.
Or in the inquiry, the VR form has been submitted, or in the inquiry, the fact of your dismissal from CRP has been supported by some evidence or not. That is all.
No, my lord, I need my solution. No.
Now we will show you. Come.
That's why I say, my lord.
Please come.
The CRPF personnel, my lord, who was there.
No.
My lord, in the disciplinary proceeding.
Please come. Page 48. Read page 48.
Page 40.
PW1 and PW2.
Yes.
What remains after that?
PW1, PW2. Yes.
Exhibit 5 and 6. What is Exhibit 5 and 6 produced in the inquiry?
Yes, my lord, these two letters were denied by the commandant.
You cannot go into it now. This is accepted.
This is what is found in the criminal trial also,
Maybe.
as well as, my lord, in this proceeding also.
No, in this proceeding, this has been
This was
relied
marked as exhibit,
Yes.
but, my lord, later on the authorities, the disciplinary authorities themselves says the CRPF has denied issuing these letters.
An extra Exhibit 5 and 6.
Yes.
Then how it was, how an order of punishment was awarded?
Absolutely, my lord. That's my point, my lord. That's why I was taking, my lord, to the evidence of the CRPF personnel who himself says we have not issued these letters.
Sir, PW2 is right before us.
Yes.
We are looking at PW2 at page 48.
Yes.
Reply of CRPF was received in September in two separate letters. Correspondence with CRPF was continuing by such and such. The punishment awarded, the PW denied that you in collusion with some other. So there is material.
No, my lord, kindly
This is denial.
kindly turns to, my lord, the finding which was there.
Yes.
At page 51.
Yes.
My lord, one will find in that page the last paragraph, the first information. What has got that, my lord? Kindly say it was not issued by them. Categorical finding. And my lord, PW9, just page. my lord, furthermore, adding to this PW9, the CRPF personnel, my lord, at page 50 in its evidence, my lord, kindly sees, my lord, says, my lord, we have no document to substantiate that this charge sheeted officer of Pankaj Kumar Mondal is the same Pankaj Kumar Mondal who worked in the CRPF. There is nothing on record in the CRPF's document. So, my lord, these two evidence.
That was not an issue to be established, whether you are one and the same person. The issue
Because
was
my-
whether you have committed that offense or not.
They could
That
not
was
produce.
not an issue.
This was, my lord, subject to correction. This was also because my defense was I was not that Pankaj Kumar Mondal. That was one of the, my lord, my contention. And, my lord, that's why, my lord, records from the CRPF was called for. And, my lord, they have failed to substantiate to that extent also. And, my lord, apart from that, my lord, the commandants themselves in the proceedings says we have not issued those letters. So, my lord,
How many documents were produced from the CRPF?
my lord, that I have to scrutinize.
About
They were,
20.
my lord,
About 20.
2022.
You are talking of one or two documents.
No, my lord, rest of the documents in my respectful humble submission
So
doesn't touch
therefore,
upon
these
those
2-3 documents, it may not withstand the scrutiny required in a criminal trial.
No.
Even if one document is there on the preponderance of probability, that is enough in the inquiry.
No, my lord,
Now, whether benefit of the acquittal can be granted, that is the only thing, nothing more than that.
now, my lord, if this from this evidence, my lord, and my lord, other evidence also, my learned friend would show, my lord,
We are looking at it. We will call on him, but we are looking at
Yes,
it. That's
but-
why we said you are repeatedly referring to 2 documents.
Then, my lord, may I just come back looking
There are
at
about
22 evidence.
There are about 22 documents.
Then, my lord, may I come back with this 22? Look
No,
into
it is all here. You need not come. We are not going to sit in
the
appeal.
authorities.
We are not going to examine the correctness of the
No.
disciplinary
Not for
authority.
my satisfaction. My lord, because the
Just
authorities.
have a look. We are telling you, have a look at page 52. Everything is there in black and white.
Yes.
Assistant teacher from the school has appeared. ASI has produced a document.
PW7 is also.
There is your confession in the OR. Everything has been considered.
Now, my lord,
There is your confession before the criminal trial.
now, my lord, the confession, my lord, before the police authorities, my lord, the order.
Before the CRPF. You have confessed before the CRPF.
No, my lord, what I can understand, my lord, from the criminal trial,
Yes.
my lord, even that was not proceed because the
Forget
person
about it.
from the CRPF came in.
Forget about it. We are not, see, again and again we are telling you, we will not look into the correctness of the decision of the disciplinary authority. All we are required to see is whether the witness and evidence was one and the same. Therefore, we told you how many documents were produced.
My lord, in the criminal
22 documents.
22 documents, my lord, out of those, all documents were placed in the criminal trial by the prosecution.
We don't know.
That's
We-
exactly, my lord, the
we don't-
criminal
We
judgment
don't,
would
we
show.
won't find it from the,
Judgment from the criminal court would show.
from that only we are looking at it.
Criminal court.
We have just shown you there are only 2 findings.
No, findings, my lord, out of, my lord, this entire
The
examination.
criminal trial may have recorded 100 documents. It bases its conclusion on 2 findings. So we need not go look into all those 100 documents. The reason for acquittal is articulated in paragraph 34. Now, whether that reason can be, the benefit of that reason can be extended in a departmental proceeding. That's the limited scope of this proceeding, nothing more than that.
May I come
Now,
back to this the day after tomorrow, just on 5 minutes, nothing more.
as prayed by learned advocate for the
He's traveling here. না এখন দরকার নেই নেক্সট দেখো লাগে সব ঠিক
My appeal, my lord, I appear for the appellants, my lord.
Private respondent.
Lord, pursuant to your lordship's last direction, my lord, we have sought upon the private respondent, though, my lord, he is appearing, my lord. This matter pertains to the qualifications.
Learned
which-
friend indicated, Mullah, before the matter starts that they would possibly be taking not today.
But I've
Because,
been
my lord,
told by
my
Mr. Mujumdar you start the matter, he will join, my lord.
lord, in that event, my lord, I will be seeking for a day's accommodation, my lord. I am being led by
Not
Mr.
today.
Rajoshi. Lord. This will appear, my lord, tomorrow, your lordship. Great.
Tomorrow it will come.
Very well.
Contract.
13,
Lord, my lord,
item 12, item 12.
For the respondent in this matter.
I think praying for a week's time.
As prayed just after a week.
Third August.
As your lordship please.
Item 13,
Lord, item number 13, my lord, I am for the applicant, my
I
lord.
beg to prefer the respondent, my
My
lord.
lord, in this matter,
I
my lord,
would-
I am being led by the learned solicitor general, my lord. Now, my lord, if the matter can be taken up at 2 p.m. today, my lord.
Today, my
Not
lord.
today.
My lord,
My lord,
can it be
any,
some other day? Can it be some other day, my lord?
lord, any day at 2 p.m. if my lord can kindly fix it, my lord.
And adjournment is sought. What is the issue?
My lord, the issue is basically, my lord, that a tender was floated by Steel Authority, my lord. Now, my lord,
10th, we have 2 p.m. Free. 11th, blank. 11th at 2 p.m.
11th August, my lord.
my lord, if my lord, may I submit, my lord, if it can be preponed, why, my lord? Because if it can be preponed, my lord, instead of 11th August, if it can be any day earlier, my lord.
Court's diary is not.
You want an adjournment and you want early, both at the same time.
My lord, then 11th August, my lord, at 2 p.m.
We have to consider both sides.
Grateful, lordship. 11th August, 2 p.m. 11th, 2 p.m. Grateful, 11th August. Item 14,
Lordship, I am for the appellant, Lordship. I am paying for short passover, Lordship.
Not today. Call the next.
item 15,
15, my lord, I am for the appellant. Well, in this matter, my lord, the same issue is before the Supreme Court. And from from December 25, it is not, my lord, nothing, no development, my lord. Yes, sir, 2 occasions, my lord. No change, my lord. I have taken go to the back. Appellant. Arup Bosupar.
what would what will
This is the number.
September. It is my 7th September. Must 15th, 13th, 14th September. 28th September. Item number 16. The department is not. Hmm. 28 September. Item number 17.
For reinstatement. Now he has already crossed the age limit. Because all he was seeking in the appeal was the reinstatement. Because the rest of the matter is before the writ court, still pending. Yes, my lord. Reinstate, re-engage. There's a solitary prayer. Page 12 of the application, CAN application. My lord. No, it is, my lord, security guard, it was contractual. Doesn't come. That is my defense in the read court.
That can be only in respect of a permanent employee, not in respect of a contractual. Anyway, none appears for the appellant.
Item 18.
None appears. Dismissed.
Item 19, my lord, I appear for the respondent ECL because the copies have not been served, my lord. I think.
My lord, I beg to appear on behalf of appellant, my lord. My lord, all papers are lying with my junior. He is very much disturbed, which is selling father. Which is so I am praying for fortnight time.
My lord, let's say I have no objection to that, my lord. But only, my lord, there should be a direction to serve the copy.
August.
10th August.
Give him a copy. Give a copy, please.
Item number 20.
This is an appeal by the state.
Intra-court appeal. Intra-court appeal.
But Chupil, kindly send down the records. I need to take the details and retrieve the bill. I don't have it.
As spread matter is adjourned 2 weeks.
কতদিন? 17 dollars.
I am for the appellant in this matter. The first time.
I am for the respondent number 3.
Other respondents are there. So for Durgapur Projects Limited is there, WSCDCL, Power Department, State Government. There are so many respondents are there. Let a copy be served to all the respondents and your lordship fix the matter. Say. এটা নিন তো আদেও ইন্টারেস্টেড কিনা ক্লায়েন্ট সেটা একটা ব্যাপার
Yes, very limited scope. What is it? Tell us.
No papers is lying with us. I do not know whether the client is at all interested to proceed with this matter. Your lordship kindly adjourn the matter for some time so that I can take instruction.
Has to be at least after 1 week.
Serve the state lordship.
We'll see. Let him make out the case. 1 week.
Grateful. 3rd August. Yeah. 3rd August.
In the meantime, he can give you copy. We have not prevented.
Serve on the GP itself, lordship. Now that is.
Item number 22.
আগেরটা 3rd August.
None appears. Dismiss. You're appearing for the state.
No, lordship. Now these matters, lordship,
None
are
appears
coming
for
to
either
the department.
parties.
No, I'm not appearing.
Item 23.
Your Lordship, Mr. Kaulul Basu is appearing on behalf of the petitioner. Lordship, he is preoccupied in a matter. Your Lordship kindly keeps it a pass over, Your Lordship.
Not today.
Grateful, Your Lordship.
Item 24.
I am for the appellant, my lord.
My lord, I am for the respondent. My senior is coming.
Let's see.
My lord, last occasion, my lord wants to the rules of the Bongyo Gramin Vikas. The same thing. Here our case is that 1/3 and paid.
2/3 paid.
That they have paid. Pension. 1/3 is paid. Last occasion, my lord will find that is the order, my learned friend appear not able by the progress. And my not to the
Not today. Not today. Call the next.
my lord, please just
Call the next.
Item 25,
24. 25, my lord. 20, only one of the appellate, my lord. No, last day, my lord, he has submitted, my lord. Today, my learned friend will submit, my lord. A soft reply will be given by him on the next day.
For reply, we will not keep a separate date. Ask him to come tomorrow at the same time.
Next week, my other matters are pending. They are not delicate. I'll keep it next week.
All right. As paid list in the next week. As paid by the Union of India.
Item number 26.
My lord, I am for the respondent, my
I am
lord.
for the petitioner, my lord.
My lord, pursuant to your, my lord, pursuant to your lordship's order, my lord, a report was to be filed before your lordship, my lord. I am placing this.
You have given a copy.
I'm giving, my lord. Just now I'm giving.
We directed for report.
Clarification actually. My lord, may I read, my lord?
No, when did we direct for filing a report?
No, it was for clarification, my lord. It was for the clarification, my lord.
When? Where is that order?
The last order, my lord. It was on, it's there in the report itself, my
My
lord.
lord, at the previous date, my lord has asked the clarification regarding the any guidelines regarding pertaining to the hesitation marks.
Oh, so now they have brought it.
Yes, ma'am.
Now
My lord, may I
they have
read?
just submitted.
May I read?
Give him, let him see.
I have given, ma'am. কতদিন কত Third August একটু চাপ হয়ে যাবে My lord, third August I will be in a bit.
Yes, wait. Which date you want?
Any day, my lord,
Yes, sir.
except third August, my lord.
Any date suggested by the court is always the most troublesome.
No, my lord, it's never, my lord.
Usually, yes.
It's never, my lord.
No, when do you want?
My lord,
Fourth,
third
fifth?
will be on fourth, fifth, any
Fourth,
day.
fifth, any date.
Fourth is Saturday, fifth is. Oh, my lord, third day, my lord, third will be contempt, my lord. Fifth, my lord.
$27.
I'm appealing for the petitioner.
Sir,
I am for the respondent petitioner. My senior has engaged in different court. I am praying for and not today.
Well, this matter, Your Lordship has heard and passed an order, but unfortunately, the order was passed in the previous.
Oh, this is that.
Yes, yes, yes. And the-
Let him be here, not today.
well, not today.
Not today. You want a longer time?
No, no, no. I thought Your Lordship passed it over.
No. I don't believe in this Passover business. Nobody knows when he'll be free. He'll be in a rush there. He'll have to rush here.
Item 28. I beg to appear for the petition application.
Hey, you should not go in appeal. That is the only issue. My lord. Why you should not go in appeal? That is the only issue.
My lord. Issue before the learned single judge was initiation of departmental proceeding after retirement, not in consonance with the Service Regulation 2010. Without adjudicating the issue, the learned single judge referred the matter and directed to prefer appeal before the appellate authority. My second submission would be that no order can be passed beyond the scope of the pleadings and relief sought for it. Here the case was, my lord, just before 3 months of his retirement, first show cause notice was issued. Petitioner submitted his detailed reply to the show cause notice. Thereafter, 3 days before the retirement, another show cause notice was issued. That is on 27th of October. And my lord, petitioner was allowed to retire. But kindly have a look. Page 73.
No. So we have seen October 31st is your date of retirement, and in February thereafter the charge memo was issued. According to you, there is no provision in the service rule which gives them the liberty of proceeding after retirement. This is your case.
Yes.
So where is the service rule? Show us.
But kindly have a service regulation at page.
Did you raise this or when they served you with the charge memo, did you respond to this? Did you respond to the charge memo saying that it is without jurisdiction, there is no authority to proceed against you?
Yes, I submitted my job. I'm coming to that. Kindly have a look, page 56 past, the service regulation.
So who is appearing for the bank? Then he will be required. You have served, let the learned advocate for the applicant.
My lord, kindly permit me to, my lord, mention item number 13, where your lordships have been pleased to fix it on the 11th.
11th at 2 p.m.
11th at 2 p.m. My lord, I brought my learned friend, but could it be, my lord, on 7th at 2 p.m., subject to your lordships business permitting, my lord?
7th is a Friday.
You are in difficulty on 11th.
Yes, my any day, my lord, before 7th, my lord, whichever day, my lord, is convenient to the court, my lord.
No, if we would rather have it after that weekend, after the 8th, 9th weekend.
But after 11th, it will not be feasible, my lord. Because after 11th, my lord, kindly doesn't postpone, my lord. If it is a preponement, my lord, then it is okay, my lord.
Why? What is the difficulty?
The difficulty is, my lord, first of all, my lord, there is a Supreme Court order, my lord, saying that, my lord, the proceeding has to be disposed of as early as possible, first. And secondly, my lord, we are suffering an interim order.
There is an interim order?
There is an interim order. Challenge to an interim order, my lord, this is. So we are
The appeal is against an interim
order.
Past December 2025.
Yes.
December 2025.
My lord, after
That is almost
after
8
that
years, 8
much
months.
river has flown through the Ganges, my lord.
কি হবে?
No, the instructions, my lord, the authority.
Again, no, but I have no difficulty if it is before 7th any day.
But I have no difficulty any day before 11th, my lord, subject to it is.
No, we'll not be able to have it before that weekend because we also have to see our business.
Right.
It can't be. We have checked, then only we have given after the 8th, 9th weekend. So 10th
Then
weekend,
kindly, my lord,
10th week.
keeping over, my lord, the next week, my lord, if your lordship may keep it, my lord, in the week starting from 17th, any day.
Lord, after
10th also you can't.
No, my lord.
12th, 13th, 14th, any date in that week.
Oh.
So today is what day? Today is 27th.
Actually, Lord, the mistake is on our part. I tried to take instruction from Mr. Dotto, but he was arguing a case, so I could not inform. That's the only difficulty. I am extremely sorry, Lord.
First week we'll not be able to do it.
7th.
No, 70 before 11th, after 11th Corona.
So let's see, they will start.
My lord, we will start, my lord, if Mr. after the word joins, my lord.
But we'll have to then
But in that case, we have kindly hear them on 11th, my lord.
That's what we are saying. We'll hear them on it.
Fix a date for me, my lord, the next week. Well,
So it is understood.
Yes. Well, I'm grateful.
Item 29.
And I'm paying for not today. I'm led by Mr. Shomu Mujumdar. And it's
not today. Yes. What do you want?
What? I do it too.
Item 30.
Last occasion, there was a direction upon the ECL to pay the provident fund as well as pension, and we will receive the provident fund and pension and other retirement benefits without prejudice to our rights and contentions. Till date, we have not received a single farthing.
Lordship, I'm led by my senior Mr. Shivshankar Banerjee in appearing on behalf of the ECL. Your Lordship, I'm praying for a note today on the grounds of his poor health.
No, what is, do you have any instruction? What has been?
Lordship, I am not carrying any instructions as of this moment.
Let him come tomorrow. Let's see.
Sir, but not this week, sir. Lordship.
I won't mind to, if I'm not standing in the way, but 1990, I'm not receiving anything.
I have sprayed.
Even I'm for the respondent.
Lordship, I am for the appellant. Was praying for a short passover. Your
Not today.
Item 31 and Your Lordship 40. Both are connected matters.
You are appearing in both.
Your Lordship, both.
Very well. Both not today.
32.
With regard to item number 13, my lord. My lord, I'm extremely sorry, my lord. I'm extremely sorry, my lord. If it can be on 17th, I have talked with the other side, my lord. It is okay. If it can be on 17th, 2 p.m., my lord. I'm extremely sorry for troubling your lordship. 17th at 2 p.m. my lord.
Yes, sir.
Yes.
Item number 32.
None appears. List after one.
Item 33. Lordship, I'm praying for a day's accommodation, your lordship. Yes, your lordship. We have assailed an order passed by learned single judge of this honorable court, your lordship.
You are the red petitioner.
Yes, your lordship. The petitioner before your lordship participated in the examination of West Bengal Audit Accounts and Audit Services, your lordship, in the year of 2017. He succeeded in preliminary examination, and thereafter, your lordship, he appeared in the main examination as well. However, the list of the candidates who was successful in participating the main examination, that was not published clearly, your lordship. Regarding that, an RTI was preferred.
So 8 years later, you have filed a writ petition. And you want a not today.
Lordship,
What is the issue? Tell us.
Lordship,
Ranvijay Singh's judgment has been relied upon. You have seen the judgment.
Lordship, we have been recently briefed with this matter, your lordship.
That is not the concern of the court. Sorry. We are not concerned. When you have got the brief, you have to take the responsibility.
Lordship, I'm having the soft copy of the brief, your
No. What is this? This is nothing. Just read the opening line of the judgment relied upon. What does it say?
Lordship, the writ
It starts with an expression, oh, what a mess.
the dispute.
That is what you want us to
The
do.
petitioner,
Look into the entire exam.
the petitioner challenged before the writ court, before this court, regarding
Why after 8 years? That's the only issue. Tell us.
not after the 8 years of the examination. The gist of the matter was that an RTA application was preferred by the petitioner.
Yes.
And in the reply to that RTA application, the relevant information which was sought by the petitioner was not provided by the commission, your lordship.
Very good.
Regarding that grievance and predicaments, the petitioner challenged that writ petition.
Where is your prayer in the writ petition? Come to the prayer portion. Which page?
22.
Page number 22, the prayer starts like, I had prayed before the
Page 22.
21, the prayer portion starts,
To be granted, but 22, Lordship.
22, a writ of and or in the nature of mandamus commanding the respondents, the Public Service Commission, West Bengal, to provide proper answer to the petitioner in the application under Right to Information Act, being annexure P6 to this writ petition, and also to provide the number of last selected candidate in the recruitment process of West Bengal Audit and Account Service Recruitment Examination 2017 for the interest of proper justice. My grievance was this, Your Lordship. I preferred an RTI application seeking certain information from the concerned authority. Not the entire reply was made against my contentions made in that RTI application, Your Lordship. Page number 36 is my RTA application, which was preferred by the petitioner.
First examination was MCQ.
Yes, Your
And
Lordship.
second was subjective.
Subjective. First was the preliminary stage. Objective wise questions was there, and thorough examination held in the main examination, Your Lordship. Lordship, one HON'BLE prayer, Lordship.
P4 is at which page?
Number 32, Your Lordship.
30?
32, the admit card. 32.
So first RTI you have filed in 24.
24.
What do you want to say? Tell us.
Granting a day's accommodation to your lordship.
No, sir. What days accommodation in this? Nothing. There's nothing in this matter.
Actually, your lordship, in this matter, I'm
So you are saying that you have not been provided this information. We'll consider. That's all. Take down. Or the
one in this lordship. My prayer in respect of B and C, lordship, to provide information. Lordship,
nothing. We will not do that.
Lordship, kindly
This
direct them
is-
to provide the information. As I have made RTA application and
You go before the appellate authority. Why late court? There is an appellate authority under the RTI.
but lordship,
Sorry.
kindly consider that the
No, we will not. Call the next.
lordship then kindly provide me liberty to prefer that.
Nothing, we'll say nothing, will not give you a fresh cause of action in relation to this stale matter. We are very
Then,
clear.
lordship, kindly give
Call the
liberty.
next case. We have passed the order.
Item 36.
Six, my lord. I am for the respondent writ petitioner. My lord, the issue has been decided by the honorable. But let me be very candid, my lord. What my learned friend is trying to apprise, my lord. My lord, in this matter, my lord, in a similar rate petition, in a similar order, that was directly challenged before the Honorable Supreme Court. My lord.
What is the issue?
My lord, issue is, my lord, the Honorable Supreme Court, my lord, in the similar matter, what happened, my lord?
What is the issue unless we know?
Yes. The writ petitioner, India the bank. The writ petitioner was a teacher. Now
Was a
teacher, full teacher. She lost her job because of the order of the Honorable Supreme Court. Now, in that very order, the Honorable Supreme Court was pleased to observe, my lord, they are relying on their case on paragraph 47, my lord. Page 111. Some of the appointed candidates who do not fall, my lord.
Yes.
My lord. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with autonomous bodies, etc. In such cases, though their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities.
So she left your service to join.
She left our service bank and joined the school service under the West Bengal government.
So she applied.
She applied.
Pursuant to this observation.
Now, what happened, my lord? Our contention was that because this order has been passed because of the fault committed by the state government. Their appointments, they lost their job. These persons. So this direction, this autonomous body is supposed to be read in the light of the state government, my lord. That is our contention. These autonomous bodies are state government because it is stated by the state government or with autonomous bodies. So the autonomous body will get its color from the expression state government. So this is the Bank of India, my lord. It is not any way related with the state government.
So can we clarify a decision of the Apex Court?
My lord, kindly see the Apex Court, what Apex Court has held, my lord. My lord, I will very... My lord, perhaps no reason was given while dismissing the SLP. The Honorable Apex Court was pleased not to give any reason. My second paragraph, we find no ground to interfere with the impugned judgment and order passed by the High Court, hence special leave petition is dismissed.
So what was directed by the learned single judge?
My lord, the impugned order is, my lord, kindly see. My lord, at page 127 of the writ petition, of the stay application.
On his judgment, the impugned order was passed, which was dismissed by the...
No, I agree to that. This same order, only the bank is different. This order of the Honorable Apex Court is in relation to a state government, State Bank of India, and this is Bank of India. Same order.
So State Bank, is it your submission that the State Bank is an autonomous body of the state government?
No.
Then
this order passed by the Honorable Apex Court is in relation to a matter of State Bank of India.
So therefore,
the banks are different, but the order is same.
Therefore, if one bank is to be held to be covered by this observation, then the other bank also will be held to be covered by that. There is no scope for holding anything otherwise.
My lord, before my lord passes any order, my lord, may I be permitted to place this decision of the Honorable Supreme Court?
No. What is left? If you are relying on this and this, then what is left? There is nothing left.
No reasons has been assigned, my lord. Kindly see.
Therefore,
because dismissal of SLP by non-speaking or speaking order, what is the effect, my lord? Only this, obviously, my lord, what is falling from my lord is since
this has already been tested by the division bench also.
Directly they went up to the Honorable Supreme Court without going through the Honorable Division Bench. I was also there in that matter before the Honorable Single Judge.
In this case also?
In this case also.
So how directly you went to the Supreme Court?
I do not know, my lord. I do not know that answer.
It was a writ petition or it was an SLP? No, it is a
writ petition. Writ petition from the order of the Honorable Single Judge, they went directly to the court.
You appeared in this case?
Yes.
Well, may I be permitted? Maybe I may not have a very good case, my lord, but may I be permitted to cite this, my lord?
You address on this also.
My lord.
So there is no dispute regarding facts. There also it was a bank, here also it is a bank. There the writ court held covered by the observation. Here also the writ court held covered by the observation. So the matter traveled to the Supreme Court. What is the effect of that? Order passed in SLP, that is only to be seen. There is no other dispute. He is relying on this judgment.
Submit, my lord. Whether or
No, come with judgment. Come with judgments.
my lord, I will come with judgments.
Then come with that. No be piecemeal. Come with that.
I would say the previous Supreme Court
As
judge
paid
will cover some.
by the parties list.
Monthly list. 1000.
Volume 6, 35.
Item number 3759.
1000, volume 6, 359.
But I appear on behalf of the respondent number 5, man.
The petition before your lordship, initially appointed under the judgeship of Bordhman. There they paid for transfer as copyist. Copyist. 2014, my lord, they applied for transfer. Order was passed by directing to join the respective post, and they should be placed at the bottom of the gradation list in the year 2017. Because they transferred in the year 2017. Subsequently, a promotion list was published by giving promotion from the date, prospective dates. Subsequently, that promotion list was revised based on the notification issued in the year 2024.
Yes.
And a fresh promotion list was published, where in the year subsequent to year when the second promotion list was published, there we have been put to the bottom of the gradation list. I initially, my lord, I am drawing lordship attention. So for the initial order.
After you were transferred,
I have joined.
you have joined. In which gradation list you were put at the bottom?
Initially, that is what, my lord. Can you turn to page 39? Page 40 is the typist cum copyist, grade 1, my lord will find. Number 2, on the Purka is 43 and 1 and 2.
You are at which serial?
1 and 2. Page 40, my lord. Promotion.
No, so this is the first
2017
seniority list published after your transfer.
Yes.
So how you are placed at serial 1 and 2?
My 42 and their grade is 43. And after that, my lord, even date of effect promotion is from 15. On that date, when it was.
When we are asking you, there is an order of transfer of 2014 that comes with a rider that you have to be placed at the bottom of the seniority.
Yes.
Now in 2014, when you went to the transfer place of posting at Alipur, where is your position reflected in the gradation list? First gradation list after you're joining in Alipur, where is that?
That has not been published. This
so
is the
therefore, so this is the first time that the
Yes.
occasion has occurred. Then
42 and 43. Normally I have joined. Subsequently, my lord, if your lordship can turn to page 42.
yes.
Certain dispute, I am reading, my lord, from the third paragraph onwards. Certain disputes, my lord, will find.
No, whatever dispute, there is no dispute that you have taken a transfer on request. The transfer on request is coupled with a condition that you will be placed at the bottom of the seniority. So you cannot dispute placing at the bottom of the seniority.
No, I'm not
But
disputing.
you say that you have been granted a promotion in this fortuitous circumstance.
Yes.
Because you were placed at serial 1 and 2.
No.
How long you continue on the promoted post?
My gradation is 43 and 44. My Lord, your Lordship will find.
When you were promoted and how long you continued?
Up to 2024.
From which date?
2015, 10 to 2014 and
10 to
2014. Date of promotion.
To which post?
Typist and copyist, grade 1.
And when you were reverted?
In the year 2024.
Give us the date, please.
4th April 2024.
So this is a correction of a mistake.
If that is so, my Lord, I could have understood this question. That is why your Lordship can turn to page 42 once.
No, so what is the effect? They have recovered something from you also?
Yes, the rejection of recovery. Apart from that, whether the gradation list which was prepared on the basis of the notification issued on 5/7/2021.
We have not seen any such gradation list.
Yes, page 42, my Lord. That is why, my Lord, I draw your attention. I'll turn to page 42 once, my Lord.
What is the date of that gradation list?
4th April 2024.
So that is of 24.
Yes.
Yes.
And earlier promotion list was modified on the basis of this notification.
Promotion and seniority are two different things.
Yes.
So the seniority list will form the basis of the promotion. So we are asking you repeatedly after your transfer in 14, which is the gradation list in which you were placed at such a position which entitled you to a promotion?
42. Gradation is 42 and 43.
No, this is of 24. You have got the
2017.
You have got the promotion in page 42 is of 24.
Yes, 42 is of
Not 17.
No, 17 is page 40.
No, you said to see page 42.
42 based on which the subsequent gradation list was prepared. And I have been placed, my Lord, can I turn to page 44?
You are showing us a promotion order. We are asking you to show the gradation list. That is the whole problem. There is no gradation list, sir. So fortuitous gain, can you hold on to it? Contrary to the terms of your transfer on request, you cannot. So the only issue is whether a recovery can be done. Because you say from 14 to 2014, you have continued on the promoted
24.
post. 24, so 10 years.
Subject to question, my Lord.
And probably you will say because it was not based on any misrepresentation and so.
It was held by the honorable single judge, but it was said some time may be given for the purpose of recovery. Only one thing.
Recovery.
Yes.
Recovery has been upheld.
But subject to
What
question.
is your right to hold on to the?
Yes, my Lord, that is. My transfer is in there 2017. I must be placed at the bottom of the gradation list, which was prepared in the year or prevailing at the year 2017, on the basis of which this promotion was given. I am not on the promoting post. Whether my gradation.
No. There is no basis. You have not shown any basis for that promotion order. You have not shown a single seniority list after your joining in 2014, from which you can be shown to be at such a position so as to give you a promotion.
Yes, that is what, well, at best I can produce the page 40, which is that
that's not the
42nd or 43rd.
Only issue is recovery or not.
And now, my Lord, whether page 43. So 2017 I will be placed at the bottom of the gradation list, following with the gradation list. Now I'll turn to page 43 once.
In 2014, you are placed at the bottom of the seniority list. How can you get a promotion in 2014? Simply impossible. And you want to hold on to that benefit of promotion granted in 2014.
No, this was issued in 2017 March.
Whenever it is issued.
So therefore, if that be so, my Lord, can I turn to
will be based on the position prevailing in 14.
14.
Not on the basis of position prevailing in 17.
17. I'll turn to page 44. Then if my gradation list.
To serve a notice, we'll consider regarding recovery at least.
So the recovery portion, my Lord, I am praying.
Let's see. Let a notice be served on the learned, on the respondents.
Appellant.
Your Lordships, Mr. Ujjwal Ray, he is leading me in the matter. He is in some personal difficulty today. I'm seeking adjournment just for today.
Grateful, Your Lordships.
The IP for the appellant.
But I appear for below the respondent numbers 1, 2, 4, 5, 6, and 10. 5 respondents. No, there are others also, but I have not. No, they are private. Bangladam only for yes. Well, so all respondents are not represented. No. 1, 2, 4, 5, 6, and 10, my lord.
Yes, these are, my lord, some of the petitions.
Yes, the employees want to know before we proceed, are they all represented? Is there proper service or that is required? If that is required, then what has happened, my lord, most of the employees will have retired in the meantime. So even if they are those petitioners, they have to be noticed, whether retired or in service, that does not. They have served, my lord, I am not aware. What is the direction?
But the direction is, my lord, primarily to, my lord, keep seniority from a backdate. This is, my lord, the fundamental direction, following by consequential, my lord.
Monetary consequences. Yes. Gotcha. So at least ensure service upon all of them so that we can proceed.
Well, I think, my lord, we have served the learned advocate, my lord, who was appearing, who had given a contempt notice. Now, I think the petitioners are divided in amongst themselves.
Possibly not, as I have been told, my lord. In fact, I also made a query from my clients who I am representing. I was not there in the trial court, my lord. So I understand seems most of them have retired in from service, my lord. Some are staying outside. Possibly they have been served, but they have not come forward.
No.
It's a monetary benefit, my lord. Ultimately, if one gets, my lord, everybody gets it.
Are you trying to say we should proceed in their absence?
Lordship, can be proceeded.
How can we proceed? If we decide to interfere with an order in their favor, can we do it behind their back? If you are proceeding on presumption that the appeal will be dismissed, then we don't. Otherwise, how can we?
But it appears to be somewhat difficult for us to serve them, because though, my lord, my client must be having their addresses, but in the writ petition, they describe themselves, all the 13 writ petitioners, working for gain at so and so place.
So how many do you represent?
My lord, I represent, my lord, 1, 2, 4, 5, 6, and 10.
So six
of them.
7 more remaining.
Yes.
One is, I believe, you know, the workers union or.
Okay, so therefore 6 more remaining.
Yes, because
14 is the workers union.
But there's a Shromik, DVC Shromik union. That's the
Make an
workers union.
endeavor, you are the employer, make an endeavor to effect service on these 6 persons. We don't know, we can't say that the same lawyer is bound to appear. If he does not have instructions in the appeal, he may not be appearing.
In fact, my lord, I was not there in neither my advocate and record. We are not there in the trial.
No, unless he is authorized, he cannot.
He cannot. So therefore, we have to at least make one endeavor to serve a notice on them.
You have a substituted service for are they these people?
Make a service on them. You will get the details from your office records. Whatever is the last address, let's see what happens.
আমি হচ্ছে 1, 2, 4, 5, 6, and 10.
What I was suggesting, the writ petitioners who are still working, we can give a notice.
No, they are already
I'm representing them, Lord. I believe, you know, 2 out of these, only 2 are working now. Rest have retired.
Out of 13, 2 working, rest retired.
So which 6 are remaining? Let us just mark it.
My lord, 3, my lord.
Just give us a minute, please.
5, 6. Yes, 3 is not represented.
No, 3, my lord, and then 7, 8, 9.
7, 8, 9.
Lordship. And my lord, 11, 12, 13, 14.
3, 7, 8, 9, 11 to 14.
11, 12, 13, and 14. 14 is the union, my lord, workers' union.
বাকিগুলোর জন্য তুমি আছো 1
They are working as workmen.
Lordship. But to cut short, my lord, I can do one thing, my lord, I can talk to my clients and see, my lord, if through them, my lord, these the other non-appearing respondents. My lord.
That's all right. At the same
Look,
time,
time.
we will also allow them an opportunity, since we are adjourning it, to effect a service.
Lordship.
Whichever.
Yes. I should take instruction, my lord,
more possible not wheels
because I asked my clients why the others are not there. Well, they said that since they have retired, some are living probably in a different town now after retirement.
Is it a pensionable job?
Lordship.
If it is pensionable, then you should be knowing their whereabouts.
Yes, yes. In any case, my lord, the employer must be having some details.
Lordship, there is compelling urgency in this matter, Your Lordship. I'm seeking leave to prefer an appeal without the certified copy. Your Lordship, I've already applied for the certified copy today itself. The order is passed on Friday. Lordship, the urgency. Your Lordship, the urgency is that, Your Lordship, there is a tender. This is a tender matter, Your Lordship. I emerged as the L1 bidder. Lordship, it has been set aside by the writ court, Your Lordship.
Tender matter, why you are mentioning before this court?
Your Lordship, the determination, irrespective of the classifications, Your Lordship has the
No,
determination
that's
to
for
prohibit-
hearing. Motion, this is not the bench.
I'll,
You please verify from the list.
Your
There is
Lordship.
another bench, we know. You verify from the list.
Your Lordship, I'll get back.
The bank's appeal is allowed, cross objection is dismissed. The bank's appeal is allowed, cross objection is dismissed.
Grateful.
You send it. There's some clear pencil corrections are there.
Item number 1 for judgment.
We found no infirmity in the order of the tribunal. The writ petition is dismissed.
Good. Item number 47.
There are two matters.
I beg to appear on behalf of the appellants in this matter. May I? Lordship, on the previous.
Send the file.
Lordship, on the previous occasion, learned Additional Solicitor General was submitting before your Lordship from the type translated copy, the questions which were put forth to the writ petitioner respondent, Lordship, wherein three things admittedly it came into light, Lordship. One is that he has checked the vehicle from the right side he checked the vehicle admittedly from the right side where there was a camera shadow area, Lordship. While he was checking the vehicle and its entry permits.
So if you remember correctly, he checked in 10 seconds.
He only checked for 10 seconds, Lordship. While
he says that yes, he was checking a vehicle and he has allowed the vehicle to come in after checking 10 seconds. He was on the right side, camera shadow area.
Camera shadow area.
Which vehicle is checked is not there,
Lordship.
And anyway.
And one more aspect, one more crucial aspect which the learned additional solicitor general on the previous occasion has pointed out before Lordship is that if your Lordship kindly takes up the charge memo, the charge sheet. There in the charge sheet we have mentioned, the appellants we have mentioned that the writ petition respondent did not check the vehicle, did not security check the vehicle, or rather he also did not check the requisite entry passes. Now, while a sentry is checking a vehicle and its occupants, it has to be two things, Lordship. One, all the occupants who are inside the vehicle, their entry passes and the permit regarding that vehicle has to be checked.
So how many, what was his name, the person who was viewing the CCTV footage? Ram?
Lordship,
what is his name?
Dharamveer Kardam.
Dharamveer. Did Dharamveer say how many people were in the vehicle at the time of checking? No.
Lordship. Because
so not only did he not mention the vehicle number, he did not mention whether there were actually 6 people in that vehicle or not.
Lordship. But it came to light by the own statement of the writ petition respondent, where he could not specify the number of people inside, but by the make of the vehicle, by the generalized make of the vehicle, he could mention, or what we could ascertain is that there could be 5 people inside. It's a big SUV. There could be. He mentioned the other way around that.
So whenever a 5-seater vehicle is moving on the road, one has to presume that there are 5 people sitting in that.
Lordship,
That is a completely far-fetched submission. Anyway, you can submit anything you want.
Lordship,
he says it's a 5-seater vehicle. He never said there were 5 people in that. You asked him how many seats. He said it's a 5-seater vehicle.
How many people were inside?
He said it's a 5-seater vehicle. He did not say that 5 people were sitting there. And even if he said, how does it help you? Your cases, there were 6 people.
Lordship, 3 fled away.
And 3 were apprehended.
3 were apprehended, Lordship.
Out of that also perhaps 1 fled away.
No.
Or all 3 were apprehended.
All 3 were apprehended, because in our the FIR from there it could be 3 persons were apprehended.
Very well.
Now the only crucial point, Lordship, which I was trying to bring it before Lordships, is that while a person checks a vehicle, that has to be the entry passes or the requisite passes issued to the persons who are the occupants of the vehicle.
You have delineated.
Also,
you have delineated the provision. You have placed it, which says that he is required to check the entry pass and he is required to check the vehicle also.
Which my respectful submission is that he did not do so.
Correct. All your submissions are founded on a presumption that this was the vehicle there.
Gotcha.
All your submissions are on a premise that this is that vehicle which Kadam has seen. Whether he says it was the vehicle or not, whether he mentions the vehicle number, whether he mentions the number, you say it is that vehicle. Now that is one fact which we could not find a support from the material on. But anyway, this is your submission.
In fact, this was one of the submissions, of learned additional solicitor, that may it be, if I may place it in a manner, is that admittedly there are the manner in which, or the choice of words which should have been there.
No, it's not a question.
There are. But
it is in substance, it is not the form which is important, it is the substance. In substance, there is nothing on record to even suggest that it is the very same vehicle apprehended later by you with people carrying hacksaw and copper wire. That was checked, which was seen by Kadam in the CCTV footage. How do you connect? You're proceeding as if it is that vehicle, and on a presumption, you are proceeding to make all the submissions.
Lordship, if I may place it, the timings of it, since the very first the vehicle when it entered,
You don't know the timing. You saw the vehicle when it was deep inside the secure area. Whether it had been cutting copper wires for the last 5 hours or 5 minutes, nobody knows. There's no see, on a presumption or suspicion, however strong it may be, can one proceed to identify the vehicle in this way?
Lordship, my respectful submission is that when the vehicle entered through the gate, that
So therefore,
timing has
we
been
have
logged
got
in.
your submission. You say he was in a camera shadow area, but nonetheless, Kadam says, and he agrees that he had examined that vehicle for only 10 seconds.
Lordship.
It is not possible in 10 seconds to examine every person sitting in the vehicle, check them, check their entry pass, check the vehicle. So there is a glaring dereliction of duty.
Lordship. Now, if I may, after that same vehicle which entered from that specific gate, that is the tunnel gate. Now, if I may take your lordship to the time frame of the vehicle which was apprehended and thereafter.
We are not sitting in appeal. We don't want to go into all these things. You are relying on this material. According to you, some material is required under a scrutiny or a judicial review. That material you have shown
Lordship.
with reference to Kadam's deposition and deposition of the writ petitioner. Now what else?
Now, if your lordship can kindly takes up the final order of punishment, lordship, which is annexed at page 177, lordship.
Yes.
The type copy of which is annexed at page 188, lordship.
Yes.
This has taken note of the inquiry report, lordship, and after going through the materials on record, lordship, it came to the finding which is at page 206, lordship. This is the type copy.
Yes.
Paragraph 13, lordship, if I may read it. Therefore, in continuation, therefore, his continuation in service is highly undesirable, and therefore, in exercise of the powers conferred under Schedule 1 to Rule 32 of the CISF Rules 2001, award number so and so, the writ petition respondent has been punished from removal from service with an immediate effect, lordship.
Yes.
Now, challenging this order of removal from service, lordship, he preferred an appeal. The appellate order 208, lordship.
Yes.
By an order dated 7th of May 2014, lordship. His appellate order, which was dismissed, rather rejected on devoid of merit, lordship.
Yes, that's what we said, 212.
212, lordship.
Yes.
Thereafter, challenging this order of appeal, he preferred a revision, lordship. The revisions order is at page 215, lordship. And if your lordship can kindly takes up page 213, that is his prayer for reconsideration, that is the revision. If your lordship kindly takes up all the prayers in his representation for revision my respectful submission is that out of these points, none of the points which he did not argue before the appellate authority or the revisioning authority cannot be argued before the single bench, Lordship. Any fresh points which he did not take before the appellate or revisional authority cannot be made, or he cannot make good of his own case, Lordship.
Yes. What is that new point? What is that new point?
Lordship, there were, in fact, he has mentioned
stating a proposition of law.
Lordship.
But what is that good point? That new point? You said that he cannot take a new plea before the writ court, which was not taken before the authorities.
Lordship.
So, how that point is relevant to your case? Which point he has urged before the writ court, which he had not urged before the inquiry officer, appellate authority, or the revisional authorities?
Before that, if I may read this revision, Lordship, once.
Which point you are talking about? Tell us.
Lordship, there are so many points which
So
he has
many
raised.
points. Very well. All right. Very well. So there are so many points he has taken in the revision, which he and despite that he has not raised all the points, which therefore he could not say before the writ court. All right. Any other point?
I'm being backed by certain authorities, Lordship.
Let us see. Give us the judgments.
This is 1995 6 Supreme Court cases.
Yes, you are relying on BC
749.
Chaturvedi. Yes.
1995
Yes.
6 Supreme Court cases. 749. Lordship, paragraph 12. May I read, Lordship?
Yes.
Lordship, paragraph 12. Judicial review is not an appeal from a decision, but a review from the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receives a fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in eye of court. When an inquiry is conducted on charges of misconduct by a public servant, the court or tribunal is concerned to determine whether the inquiry was held in by a competent officer or whether the rules of natural justice.
All right. So we appreciate what you are saying. Anything? Any other judge? So the sum and substance is that it has to be based on some material. It cannot be based on extraneous consideration. The conclusion has to be perverse. The procedure, decision-making process rather than the decision itself. What else? Now what?
Lordship, the same. Office copy cannot पूछे थे. P होने से करंट. सब बार करे भी लिखा ना. Lordship, placing reliance from that BC Chaturvedi's judgment. This is also your Lordship is aware. On the previous occasion, I have cited before. Cited this judgment before your Lordship.
Same. There's nothing.
On the same principle, Lordship.
Need not multiply. This is enough on this point. Any other point you want to?
Lordship, one more point on that. On the delay and latches.
Yes.
Chennai.
Eight 4
2014 4 Supreme Court cases 108, Lordship. Paragraph 16 and 17, Lordship.
In this case, there was 4 years delay.
This
In
case,
claiming the promotion, in claiming the promotion.
Claiming the promotion?
In this case.
In this case.
Yes, we remember.
Gotcha. And
So the apex court said delay cannot be brushed aside lightly. This has been.
there is one more judgment passed by this honorable court. It is passed by the Honorable Chief Justice.
On which point?
On the point, the discipline to be followed in the paramilitary forces has to be not sacrosanct to the civil posting, Lordship. Paragraph number 9, Lordship, takes up. It is of much higher degree.
Uniform service, central paramilitary force, high degree of integrity, commitment, and discipline.
Discipline is required. And is one more judgment, Lordship, where on the proportionality of punishment, Lordship. Paragraph number.
Both that point stems from this only.
Lordship, this point is having this judgment. This is also Lordship, it is reported in 2001, 2 Supreme Court cases 386. The proportionality of punishment in this case has been derived from the Wensbury principle, Lordship. Paragraph number 24, 26, and 39. If I may just take you, Lordship, to these paragraphs, Lordship. Paragraph 24, Lordship, the explanation on the doctrine of proportionality, Lordship.
So you are relying on 24, 26 and
26 and 39, Lordship. 26 is again of the same nature, Lordship, that the relevant factors has to be considered, whether irrelevant factors has been considered while taking the or coming to the reasonable conclusion. And whether a decision which one has arrived on that same point, Lordship. These are the ones.
Yes.
Judgment copy গুলো দেখে নেবো কারণ আমি তো I'm grateful to Lordship Lord that.
See, we'll just sum up what has been argued. Their star witness is Kadam. Kadam was viewing the CCTV. He has appeared and said, yes, this is the vehicle he was examining for 10 seconds. The entire conclusion has been drawn by the inquiry officer, sustained up to the appellate authority on the basis of this. Whatever it is, that now it is not in dispute. These are the facts. that he did appear before the inquiry officer. It is also a fact that he said that he saw the constable examining the vehicle. We have already observed, you must have heard that the lacuna appears to be that he did not mention the vehicle number, he did not mention the number of persons. So, this is the facts emerging from the inquiry. What you have stated in the inquiry, where is your statement?
My lord, I have restricted myself with regard to the appeal which has been filed by learned friend before lordship. First part, first limb of submission before lordship. First, second limb of submissions, my lord, that the trial court, it has been observed while dealing with the writ petitions that the proceeding which has been proceeded by the departmental authority, it is a no evidence on the basis of that. Correct.
That's
now,
right.
the two limb of submissions, I try to assess your lordships in a decision-making process. How could you, my lord, the justified with regard to the presentation of appeal before lordship challenging an order passed by the trial court? Now, so for the order impugned, according to my learned friend, which has been passed by the trial court, it is a bad, it is a erroneous, and the order which has been passed without following the due process of law. But these are not the argument. The argument before lordship with regard to the memo of appeal or my lord, this appeal, present appeal, that the order which has been passed by the trial court is palpably wrong, that in the light of the decision of the Supreme Court in a decision-making process, normally should not intervene. Because according to them, the trial court has committed a gross violations in terms of the provisions of the CSF Act. Now, I am asking this question to myself, Lord. So, for the order which has been subject matter of challenge before lordship, what illegality has been drawn up by my learned friend before lordship? And what point has been taken in the appeal that this is the gross violations committed by the court below, your lordship should interfere? So, for the factual metric is concerned, your lordship 100% correct, because your lordship heard several occasions this matter. And so, for the Kadam, who is a one of the witness, departmental witnesses in the DWs, he is sitting in the inside room, he is operating the computer, but didn't find the number of the vehicle, the color of the vehicle, how many persons sitting in the vehicle. There is some error or there is some miscommunications. In that way, in a departmental proceedings, a major punishment inflicted upon a trainee discipline force constable who has just completed his training and joined, and next day his service has been gone. I could have been understood that I am a senior most, I am well aware. This is the first day after getting training and joining there, and I have been thrown out from the service. I could have been understood that I am a well, and I am a well conversant of the all the SOP and others. This is the first day. Now, so for the first limb of submission before lordship, subject to kind sanction.
You have raised a plea before the inquiry officer regarding ignorance of the SOP.
Lord, the departmental proceedings, the answer which has been submitted before lordship, before the inquiring officers, he has been disclosed what he has been the actual fact before the authority.
See, just now you argue that after training, this was your first posting. So you expect some leniency because you are not expected to know the SOP.
No. Those are the head constable, those are the senior officers deported in the gate. They will at least assist me to deal with the situation. But this is not the lacuna, or this is not the submissions before lordship. I try to praise before lordship that this is the first day, number one. Number two, I disclose.
So it is your first day. So what do you expect? You have said twice that it is your first day. So what do you expect? That whatever you do should be condoned?
No. My lord, so for
Why?
the
We are asking you why you are raising such a plea. Have you stated before the inquiry officer that being a first day posting, I was required to leniency? Please forgive me, I have committed an error. Have you said that? Have you taken that stand? Then
this
why
is
you
not
are-
the case before the
Your
inquiry.
case, see, I have heard it earlier. His lordship was not a member of the bench. Therefore, it is being heard. Now, I remember very well, your case is only on this ground that the vehicle number, the color of the vehicle, there is no identification of the vehicle.
Correct.
There is no identification of the constable. He just says, yes, constable is inspecting, 10 seconds, that's all.
Lordship.
So why you are going into all these issues which are not relevant?
My lord, in that event, my lord, I am drawing lordship attention once again that the first leave of submissions, my lord, according to me,
What is your stand? Read your statement before the inquiry officer. Where is your statement?
should I start from charge sheet?
No, please don't repeat things. Show us your statement.
Lordship.
You have succeeded before the Honorable Single Judge. You have succeeded before the Learned Single Judge. So just show us what is your statement. They are trying to upset the finding. You show us what was your statement. They have raised their issues.
Your lordship straightway.
Which page?
Page 149.
149.
149, Lordship.
148.
This is the translated copy of the
148.
written statement.
No, where is the original? Original is in Hindi.
Original is in Hindi.
No problem. Where is the original? Oh, it's not legible. Anyway, so we'll refer to the translated.
Inner page 118, running page 149.
149.
Lordship. Eight. Huh?
149. But there are five types translated copy of it.
Your lordship got it?
Yes.
Would your lordship allow me to read, or your lordship?
No, we are going to.
Lordship.
Yes, we have taken that ground. I was not acquainted with the post, duty post of the. Because I was not. So you say that as my first day, I was not well acquainted with the duty. So I inquired from my officers, they briefed me. And then you say all persons and vehicles that entered the plant during my duty hours were allowed entry by me after I conducted the security check. This is your standard. All the vehicles you have conducted the security check.
Now, on the basis of the, my lord, this is the written submissions before the inquiring authority. If your lordship take trouble to the, my lord, charge memo once, my lord, your lordship have, my lord, several locations, my lord, gone through the, my lord, charge. My lord, page 88. 88. Well, should I read, lordship? Very small charge sheet. Number, article of charge. Number 1043387153 constable such and such was detailed for duty at tunnel gate in B shift on 4/10/2013 from 13 hours to 20 hours. During his duty hours, a light motor vehicle bearing registration number WP30H9084 approached the gate at about 1858 hours. The entry to the said vehicle inside the plant premises was allowed without checking the entry pass premises of the vehicle and men sitting inside the vehicle. As a result, miscreant who were in the said vehicle gained entry inside the plant premises who were later apprehended by the personnel of the unit while attempting theft of plant property. The miscreants later handed over to the police at Hirapu police station. Had, my lord, I am drawing lordship attention, my lord, had proper security check been done at the access itself by on the duty personnel, the miscreants would not have had entry inside the plant. It shows that number such and such, constable such and such was performing duty a very casual and negligent manner, which tantamounts to gross misconduct, dereliction of duty, and violation of lawful instructions. My lord, this is the charge. Thereafter, my lord, the article of charge framed against the, my lord, constable. Next page is the relied document in connection with the departmental proceeding. Next page, page 89. And the prosecution witness's name has been mentioned, or the three persons' name has been mentioned in the bottom portion of the memo, page 89. Well, so far the documentation which has been relied by the prosecutions in respect to the departmental proceeding, TCTP, my lord, is operating, but never disclose the actual fact, color of the vehicle, name of the vehicle, number of the vehicle. And the Kadam who is operating the same, he cannot disclose why it has been done. On the contrary, he has been submitted, it has been done by the petitioner while he has posted at the B gate. But what is the basis? What is the evidence? What is the reliant document? That has not been there. except Kadam, others or any evidence or any documentary evidence which can be relied in the departmental proceedings. And in absence of that, Your Lordship, the major punishment has been inflicted by the disciplinary authority. Against that, an appeal followed by the revision that has been turned down by the authority. Thereafter, it has been approached before the High Court. Now, question comes. If Your Lordship take trouble to the once again, my lord, the depositions of the charge official petitioner, opposite party herein, page 149. My lord, this is a 5 pages reply before the inquiring authority. Disclose the infirmity, defects, and also the, in absence of the documentary evidence, the proposed punishment has been inflicted upon the charge official, which leading to the trial court a view in a decision-making process in favor of the petitioner. Because in the 4 corner of the stay applications, well, I could have been understood that the documentary evidence has been placed in the inquiry officer, but while the court sitting in a judicial review did not consider and pass the order in favor of the petitioner. But in the 4 corner of the memo of appeal, there is no such evidence has been enunciated or annexed or relied by the authority, wherefrom it can be relied that this document was not been considered by the trial court, and this is a fit case to be remanded back to them. I could have been understood, but here this is not the case. So for the framing of mind of the authority, charge followed by report of the inquiry officer, as it is same, without having any evidence, it has been proved, followed by the reply submitted before the disciplinary authority, that has been same outcome, reject. Thereafter, I preferred an appeal before the appellate authority, same, they have already framed their mind. And it has been purely non-application of mind to be the actual, the allegation and the final order pass in respect of different stages of the departmental proceedings. I could have been understood. No, there is a gross error. There is a gross mistake on my part. So the punishment which has been inflicted upon me, there is some nexus with regard to the alleged allegations. Well, where? What are the documentary evidence? Which are the evidence which has been relied by learned friend? And in absence of any of the documentary evidence or any evidence or out of the evidence which has been relied, sorry to say, nothing has been annexed or relied. Now, only my learned friend harping on or banking on that the trial court, the judgment which has been passed by the trial court is not proper or is a correct one. Well, I am asking this question to myself. What are the grounds has been taken? And what submissions argue before Lordship? That on the argument of sake or the points of or the question of law can be considered by your Lordship. If your lordship take trouble to the, only I am drawing lordships, the order impugned, according to my learned friend, my lord, the order which has been passed by the trial court, relevant portion, if your lordship allow me, 2 or 3 paragraphs. Should I read, lordship?
Yes, tell us which paragraph.
A team was engaged to or depot at the tunnel brigade. If your lordship take trouble to the paragraph number 2, well, I'm just showing your lordship glimpse at page 290. Your lordship got it? Paragraph 2 of the judgment at page 290. Well, I'm reading just few lines, then your lordship again to skip up the next paragraph. Well, the facts required to be adumbrated for the purpose of effective adjudication of the writ petition are that the petitioner joined as a constable in the Central Industrial Security Force on 20th August 2010. On 4th October 2013, he was posted Constable B, timing at 13 to 21 under a company at Tunnel Gate, ISCO, ISP, Bandpur, West Bengal. One R.N. Upadhyay, Head Constable, one Muhammad Alam, Assistant Sub Inspector, were also posted in Tunnel Gate from 13 to 21. One Dharampir Kadam, Sub Inspector, Executive, was in charge of monitoring security checking at the gate through CCTV camera. My lord, the entire matter was taken into considerations by collective measures by a group of expert personnel for safety security, according to my learned friend's submissions of a B gate, of a tunnel. Now, the alleged incident, thereafter, my lord, followed by a charge sheet, and a major punishment was inflicted, escaping others, upon the petition. Now, my lord, kindly come to the paragraph 3. The visual checking and the checking of the gate pass.
Please don't read the entire judgment.
No, I need not to.
So starting from paragraph 2, you will go to paragraph 50. No. Don't read the entire judgment. What do you want? Please make your submission. We have gone through the judgment. You tell us what is your submission.
Try to your lordship's, my lord, that the...
Don't read the entire judgment. Will not permit you to read the entire judgment.
I just requested your lordship's, my lord.
Why you are giving this background? Come to the findings. Where is the finding of the learned single judge? How many times we'll go through this fact again and again? This we have already seen.
Kindly come to the paragraph number 6.
What is the finding of the inquiry officer?
Finding of the inquiry officers, all the charges leveled against me are proved.
On what basis?
According to me, there is no basis, no evidence, out of evidence there.
So he has based his conclusion on what?
Lordship. I'm showing your lordship on the basis of that, your lordship can.
He has, where is his finding? Come to the inquiry officer's finding.
Brief presenting officers report at page 151. Start from 151. It is correct. Inquiry. One start from 163, Lordship. Your Lordships, take trouble to the page 167. It has been observed by the inquiring authority in respect of the defense statement of charge official at page 167. And thereafter, my lord, it is continuing page 168 because, my lord, he has been placing observation of the defense statement and the admitted fact as well as the fact which has been disputed. And the observation, my lord, I am just relevant portion I am reading, your lordship, what he observed. Start from 169. Analysis and decisions. From the deposition of the BP Chetri was performing the duty of company commandant. Well, he was not there. He is the highest officer. He is the company commander of the unit. It has been evident that one vehicle bearing such and such with 3 miscreants, somewhere 6, somewhere 5, somewhere 3, or the SUV, my lord, is a comprising of 5-seater. I am not on that, my lord, only just were apprehended by Constable Ramnath while later were involved in the theft of the property. My lord, it is apprehended, not there is any theft. They inside, and while they are inside, they have been, my lord, intercepted by the officials and they have been placed before the Hirapur police stations. So there is, in physical or actual, there is no theft. Thereafter, my lord, further, the video footage produced at court exhibit by Dharambir Kadam in connections, it is crystal clear. One vehicle was permitted by Constable GD Ravi Kumar to enter into the plant premises without carrying out, let down the security checks. My lord, I drawing lordship attentions, my lord, from the evidence, from the depositions of the respective, my lord, witnesses, because computer is not functioning. There is no such, my lord, photo or anything has been displayed in the CCTV camera. So the observation in with regard to the, my lord, point number 2 in 169 page of the presenting officer, totally, my lord, incorrect and bad in law. During cross-examination of SI BP Chetri, charge witness, court witness, by the presenting officer, he categorically clarified to carry out security checks of any vehicle at least 2 to 3 minutes is required, where the approaching vehicle was evidently enter inside the plant premises with a very short span of 10 seconds, and the apprehended miscreants during interrogations by court witnesses staff at vehicle gate also stated that they have entered into the plant premises through tunnel gate. From the video footage of the tunnel gate available with ISP management and received by the office, only suspicious movement of a vehicle of 4/10/2013 was detected at tunnel gate. If suspicious movement of any other vehicle through either tunnel gate or any other gate was occurred on 4/10/2013, the same would have been recorded through CCTV camera and detected by the technical department of SAIL ISP Bandpur management, and CISF was informed about the incident. However, it is evident that no other suspicious vehicle movement through any gates not at all recorded or detected, which established that one vehicle number such and such, allies such and such, along with its occupant, attempted to commit theft of plant property on 4/10/2013. As a matter of fact, both the vehicle is a single one, and it appears that raising of a dispute in the number of vehicle is a mere attempt on the part of the charge official just to mislead the inquiry. Well, I draw your lordship attention to the fact. Since inception of the incident, I never disclose any number. The number which has been provided in the charge is contrary to the depositions made by the respective witnesses. Somebody says it is a Tata Sumo, somebody says other vehicle, somebody says different number, somebody says different number. So the entire burden was shifted upon me by the inquiry officer. It's totally, my lord, irregular, incorrect, and on the basis of the he has been frame his mind, an entire article of charge which has been leveled against me has been proved erroneous. Now, my lord, otherwise, if the charge official desired to establish claim, he might have asked question to this effect, PW1 as well as Chetri court witnesses during cross-examination, but he did not so, even after expending ample opportunity to the charge officials by the inquiry officer. Rather, the charge officials tried to evade the issue, which clearly established the purposefully intention of the charge official to mislead the inquiry in any manner whatsoever. My lord, I fail to understand the inquiry officers. He is the, my lord, initially ascertain the factual aspects and the truth, so that the allegation which has been leveled against him that can be ascertained properly. Now, my lord, he has been, my lord, prejudged the entire matter, and without having any corroboration of the facts with regard to the depositions made by the respective witnesses, he has been observed in a manner which shows and reflecting the prejudge the entire issue. Now, my lord, the charge official in his deposition has pointed out that he had performed his duty 4/10/2013 properly, and during his duty he has not allowed anybody or any vehicle inside the plant without permission, which is mere attempt to justify the mislead he has committed. Sub-Inspector Dharambir Kadam in his exhibit shows that the charge official during his duty permitted the vehicle entered into the plant premises without carrying any security check. My lord, drawing I am lordship here and joining the lordship, my lord, this line and this. Dharambir Kadam, what documentary evidence he has been pointed out before the inquiring authority? What document he has been shown? What document he has been produced before the inquiry officers were formed? It can be evident that I have been committed the gross mistake which has been leveled against me. Save and except he has been given depositions before the inquiring authority. No other documentary evidence, and except Dharambir Kadam, no other witnesses has been given depositions against me. Now, my lord, he further stated that, well, I am, my lord, drawing lordship attention at page 17, last 4 lines. He further stated that the exhibit shows that the charge official opened the gate, allowed the vehicle in question to gain access inside the plant, and closed the gate. Therefore, it is on record that charge official during his duty hours allowed the vehicle, and charge official presents the PW2 solely by PW1 does not dilute the gravity of the misdeed committed by the charge official as a charge, as he himself was not present during the course of apprehension. Rather, it is evident that three miscreants, such and such, were apprehended by one court witnesses personnel on port, who himself corroborated that they entered inside the plant through tunnel gate. Itself proves that charge official during his duty hours failed to prevent unauthorized access to the vehicle number such and such along with its occupant for the reason best known to him. Findings. In view of the admitted as mentioned above, an analysis of the statement of charge official as well as the witnesses. Well, I am drawing Lordship attention to this line and pausing here, Lordship. Admitted as mentioned above, and analyzes the statement of the charge officials as well as the witnesses together with discussion of point disputed by the charge officials. My lord, had there been any evidence even except the depositions made by the respective parties before the inquiring authority? Now, my lord, I am asking this question to myself, that except Dharambir Kadam, none of the witnesses are the eyewitnesses, and
why you say except Dharamveer Kadam? He is also not an eyewitness.
Lordship, he is security. He is sitting in the
he is sitting in CCTV room. So why you say except Dharamveer Kadam? There is no eyewitness.
So Dharambir Kadam, he says, my lord, yes, the charge official has allowed the, and I have seen.
Very well.
So, on the basis of the submissions of the prosecution witnesses, the charge official frame his mind and inflicted and the prove all the article of charge which has been leveled against me. Who are the witnesses? All the sub-inspectors or the constables and the company commander and the other higher officials. They have been turned down my prayer with the same framing of the mind and prejudge the issue. Now, my lord, taking note of these points, the inquiring officers' findings, what are the basis? On the basis of, my lord, 4 line, page 171. Once again, I am drawing Lordship. Page 171. In view of the admitted fact as mentioned above,
I will take my lord's leave and come back.
I am showing your Lordship, page 171. Is only, my lord, few lines. But so far your Lordship's query is concerned, I try to assist your Lordship, but by showing the relevant points. In view of the fact admitted, well, I am an inquiring authority. I have to prepare my report and place before the disciplinary authority for making a decision-making process whether the charge has been proved or not. Whatever the findings is concern of the inquiring officers, the disciplinary authority maybe disagree or maybe allow the contention from the inquiry officer's findings. But here, he started his findings. It is admitted fact. First point. Second, analyzing the statement of charge official as well as the witnesses together with the discussions of points disputed by the charge official, the charge level against constable such and such was stand proof on the basis of evidence. Well, I am asking this question to myself. What evidence has been placed before the inquiring authority by the respective prosecution witnesses? Those are acting as a court witnesses or prosecution witness in respect to departmental proceedings. But four corner of the departmental proceedings, they relied documents. It has been mentioned in the charge sheet, next page, page 89. Who are the witnesses? There is a mention. But in the decision-making process, while they proceed with the departmental proceedings by inquiring authority, and the inquiring authority or the inquiry officer who has been come to a conclusion with regard to the article of charge, he has been observed that on the basis of evidence before him. So, the findings of a inflicted of a punishment upon the charge official starts from the inquiry officer's observations, the evidence. Now, my lord, it has been carried on from inquiry officers, departmental proceedings, final order, appeal, revision, all are on the basis of evidence. My lord, I could have been understood. What evidence? Even trial court below, same analogy has been, my lord, cited by the my lord, respondent appellant here. I could have been understood, my lord, there is a gross mistake. Your lordship ample power to be, my lord, modify or my lord, set aside the order. But when it has been a case of no evidence, and on the basis of that, my lord, trial court has rejected their contention and inflicted the punishment which has been set aside and directed them to resumption of a duty of a constable. Against that order, my lord, they didn't have any respect. I preferred a contempt application which is pending before the trial court. Thereafter, my lord, appeal, stay order, and now, my lord, hearing is continued.
Very well. We have understood. Any judgments you are relying upon? Then show us. Your judgments have already been considered by the learned single judge. You need not repeat.
My lord, only what I'm, my lord, subject to kind sanction, my lord. My learned friend relying court decisions today.
Yes.
My lord, only if your lordship, my lord, I need not trouble. Only I can have a copy and
no. Today is the last.
Complete.
Finished.
Only I can, my lord, given the copy of the judgment.
These are reported judgments. They are not obliged to give you. They are reported judgments.
I am not on that.
They have cited earlier also. They are not obliged to
one judgment they have cited. Well, okay. I'm taking assessment of my learned friend. একটু দাও আমার কপি দে আমাকে তিনটে জাজমেন্টের কপি আমি দিয়ে দিচ্ছি এখন যশোরকে বলে দিচ্ছি
You've been arguing
no
for quite some time. Just come to your judgments, whatever you want to show. We are not obliged to hear the same thing over and over again. No evidence, no evidence, no evidence. We have already said at least 3-4 times. Now show us which judgments you are relying. Patience does not mean that you will continue forever.
My lord, so far, before relying the judgment in my favor, the judgment which has been relied by learned friend before lordship. Court decisions has been given by learned friend. First decisions which has been given to lordships. 1995, volume 6, page 749. It has been given to a copy lordships. Six. Koi 6 ta koi babu? 6 ta koi. 1995. Private. My lord, here the first judgment which has been relied by learned friend in support of their claim, 1995 volume 6 Supreme Court cases 749 paragraph 12 my learned friend relied. Only I am showing you losses, my lord. G. The judgment which has been relied, my learned friends, it relates to calculating the disproportionate asset with regard to the government official. So for the now the question of law which has been enunciated in the decisions head note B of the judgment, whether judicial review scope can interfere with regard to the matter. My lord, I need not to trouble your lordship having the vast experience with regard to the issue, only when it can be done.
So you have already stated it's a case of no evidence. In case of no evidence, it can be done. Now what else?
Sorry, your
lordship.
lordship. I think, my lord, your lordship, my lord, already, my lord.
You have so many times you have submitted. No evidence, no evidence, no evidence, no eyewitness. One person has appeared, he has not said about the color, number of persons, anything. Everything you have said. Now you say this is scope of judicial review because no evidence. It is comes within the scope of judicial review. So BC Chaturvedi and this other judgment of Kunasekar will not apply. Now he has relied on one other judgment on the doctrine of proportionality. What do you have to say? Tell us.
My lord, so far my judgment part is concerned, it has been fully covered by the single
It is
bench.
all covered. Yes, you have cited all the judgments, so nothing more is required. Yes. So
I beseech your lordship and I'm grateful to lordship's fellow to accommodate me to hear the matter.
Yes.
I get lordship.
Lordship, only one point
Yes.
is that my esteemed senior friend has been mentioning, has been in fact on the previous occasions as well, that the remaining two seniors whom have briefed since he was new, he was there deployed at the very first day. He was briefed by two of his seniors who were also present on that very gate. Now, those two persons, one head constable and one constable, were also charged. They were also charge sheeted on the major offense
for the same allegation.
And based on their part of actions, they have been given penalties.
They have been dealt with accordingly.
Yes, Your Lordship.
Yes.
So,
Not the
only
parties.
extension being
Yes, call the next case.
Item number 48.
Lordship, grateful to lord.
Grateful, my lord.
Hello, this is a case of compassionate appointment being challenged by us. The learned single judge has directed that they be considered and given compassionate appointment, even though they applied between 1 year and 13 years from the date of demise of their parent, which this, according to us, is not permissible.
They applied within 13
Yes.
years.
Yes, Manoj. If you turn to page 560 of Manoj, to the convenience compilation.
560.
My lord. There's a convenience compilation that we prepared. The chart over there. Mary, the columns we are concerned with are 5 onwards. Current age of the appellant. The maximum age for us is 40 years. Then date of approach, it's 4 years in this case, 2 years, 5 years, 7 years, 7 years, 1 year, 10 years, 10 years, etc. down the line. It is our submission, therefore, that appointment, coming for an appointment after so many years of demise of the relation concerned is not permissible as a compassionate appointment. In fact, if you see, Manoj, at 562, one person has come, item 27 is come after 13 years. Now, Manoj is also aware of the fact that the case of compassion appointment is a case of penury. You can only get it if you can demonstrate that you are in abject penury. My Lord Justice Datta in the Supreme Court has said it's a case of hand to mouth. No. No. With your application. Yes. Your Lordship will see also the next column, declaration of income. The question is, hand to mouth is the asset test. Here, they say that the income in the first instance is 2,500. Now we are talking of the year 2006. In 2006, 2,500 is not impossible. But at the end of the day, see the last column. In their application to us, they declare, the first person declared that he had an income of 14,500. Next one, not exceeding 86,000 per annum. Next one, 95,000 approximately. And these are all in cases where the Supreme Court has held this is not hand to mouth. Indeed, Manoj, even if you get pension and gratuity, the courts have held that is not hand to mouth. And there, Manoj, I've got a chart again. 660. At page 660.
No, the learned single judge directed to give all of them compassionate appointment.
Yes.
Let's see, where is the direction?
Can I just take you for a minute to one other thing and then I'll take you to the learned single judge. Just a few facts. Turn Manoj kindly to page 87. Let me show you what is the document on the basis of which they are claiming this right. You will also have page 87. This was an agreement between the staff and the management. I won't read it. Let's have that. Page number 87. 87. So it's 42.
Maybe not.
Page, I'm so sorry, page 40.
42. 42.
Compilation. What are you doing to me? No, 42 it was. So that means page compilation, part 1.
Yes, now we have it. Annexure P8.
Yes. I'm sorry, my paging is a little awry.
No, that's all right. No problem.
I won't read this.
As long as we get there, it's no problem.
Yes. Now, as I mentioned, I'm not going to read this. This is only an indication. This document is dated 11/1/1997. It is an agreement between the union and management for starting the process of compassionate appointment. Then if you turn, my lords, to, what is page 6 here? Page 43.
Item 4, item 4.
Come on, what's happening? Page 43, I'm told.
Page 44.
Here, my lords, will see at para.
Page 44. Para 4.
Page 44, para 4, my lords. Anyway, I won't trouble the court since my paging is wrong. Just take it for granted, my lords, that there was a board decision on 22/9/1998.
On which date?
22/9/1998.
Yes.
To freeze all unskilled appointments. So there was an intention to appoint them as unskilled category, and then there was an order saying no appointments in that category. Now the important document, my lords, comes up. Page 58, my lords. 2006.
2005.
6. Come on, what page is it?
Sir, 11.
Give me 2006, please.
Yes, 11.
But in fact, before the Honorable Single Judge, we argued from the SLP. But that contained the entire set of documents, but that was also handy for the purpose of argument, so that there would be no discomfort with the pagination. So the parties agreed that we argue on the SLP and the IA filed in connection therewith.
The last occasion.
No, that's right.
You must remember, we had said we'll file a convenience.
That's rare.
Since
Since
they're
the
going on that.
No, but it's not much convenient, it appears.
the stay petition, the stay petition runs into 10 volumes. So, your lordship desired a convenience or a shorter version of the documents.
Do my best. That's page 12.
No, how can you strain yourself if you don't have the proper?
I have it, my lords, but there's some confusion here. Let me not hold the court up on my confusion. Can I take you to page 12, kindly?
Of
the convenience compilation. So this is an order of this honorable. This is an order of this honorable court, and at page 15, your lordships have held that we recognize the fact that there is a freeze on appointments. As soon as the freeze gets lifted, consider them. That's at page 15. Then, my lord, the next thing I like to see is page 39. Page 39. At page 40, you also find para 17. It says, after discussing on the subject, the board of directors directed the company to re-examine the proposal in reference to other shipyards in neighboring Kolkata, West Bengal, especially Kolkata port, and to reframe the policy depending on the current trend.
Mr. Majumdar, you have a copy?
I have, but the pages are almost
telling. No, paper book. The copy of the paper book.
Yes, the convenience brief.
Yes. No, they have given us a
convenience brief.
Yes.
Some of the pages are telling, but not all.
We saw that you are trying to.
Not the same boat.
You don't have a copy of
Yeah, we have.
No, you were peeping into his brief, therefore we saw.
I was trying to tally the page number.
I'm extremely sorry.
No, please carry on.
Page 40, my lords.
Yes.
This is the minutes of the meeting of the board of directors dated 29/3/2005. Now turn to paragraph 17 on page 40.
Yes, we have it.
My lords have that paragraph?
Yes,
please.
Very
well. Please turn to the next page, as 42. Do both my lords have that now? And 42. These are minutes of the meeting between staff and management. There are two dates given here. Kindly note them, my lords, because you'll come across different dates sometimes. 24/3/2006 and 11/5/2006 are the dates of this. Now, this is important because the workers' claim is based on this. Either they succeed or they fail by demonstrating that they come within the ambit of this document. So let us understand what the document is. If your lordships will turn to page 44. I'm sorry, can I request you to turn to page 43 first? Paragraph 2. In response to CMD's opening remarks, the union stated that the issue had been deliberated in detail in the last wage settlement dated 28 March 2005, wherein the union has expressed its willingness to cooperate with the management to meet the business challenges. Regarding the issue of compassionate employment, the union, via letter dated 11/3/06, demanded that the management shall maintain the complement of permanent operatives existing as on 31/12/2005, and the shortfall into the same shall be filled up first from the panel of died in harness categories. The union also stated that there is no need for formulating a comprehensive policy on the subject of compassionate appointment, so that the families of the GRSC is a company, employees who died in harness do not suffer. What I want to pause for a moment here and bring back your lordship's attention to the middle of the paragraph after December 05. My lord said that December 05, and the shortfall into the same shall be filled up. So the died in harness. I'm sorry, my lord. Is my lord with me at page 43? At page 43, paragraph 2 I just read. Let's go
as on 31st December 2005.
After that.
Yes.
And the shortfall into the same shall be filled up first from the panel of died in harness. So died in harness didn't have a separate category. They were there just as an in-between fixture, in-between permanent employment. Then please see the next page for 44. Paragraph 4 on that page.
Yes.
In continuation of the discussions held on 17 June 2006, and so etc., after prolonged discussion, it was agreed upon that the company will commence recruitment of the operatives in category of skilled and unskilled to fill up existing vacancies, which will inter alia include provision for compassionate employment as per phases given here. So once again, they were to fill up the regular vacancies and include, to the extent possible, DIH. May I use the short form, DIH, for death in harness. Then the next paragraph, dependents of deceased CRESC employees who have died in harness and were the petitioners and writ petition number so-and-so of 1999 will be provided compassionate employment in first phase, which will be completed by within 30th of June 2006, subject to conditions stipulated in para 5 below. B, in addition to the above, 50 dependents of deceased employees who have died in harness will be provided compassionate employment in second phase, which will be completed by 31st December 2006, subject to conditions stipulated in paragraph 5. The remaining dependents of deceased employees who have died in harness up to 31st March 2006 will be provided compassionate employment subsequently in a phased manner in 2 or 3 batches as applicable to the to be completed by 30th of June 2008, subject to conditions stipulated in paragraph 5. For the purposes of vacancies, for this purpose, the vacancy will be notified through press advertisement as per rules and procedures of the company. Care will be taken so that the rights of other people for employment in the company are not jeopardized without vitiating the phrases mentioned above. Now, paragraph 5. The other conditions for compassionate employment are also discussed and consensus reached as below. Dependents, only one dependent, son, daughter, or widow will be eligible. Then paragraph B, Manoj says that there should be no earning member, which is the essence of compassionate employment. Then 3, Manoj, age was fixed as an age, maximum age of candidates shall be governed by the rules of the company as applicable. And qualifications, applicants should have the requisite minimum qualifications as per the rules. Now, what has happened?
Yes.
What has happened is a fundamental mistake. Compassionate employment is meant, father dies today, I don't have employment, I need the job desperately. What has happened today is that they have been treating this as regular recruitment. they've been advertising for these posts. You can't advertise. Now, I will take responsibility. We ourselves misunderstood this whole thing and we went along and advertised. So therefore, I would submit that between the two of us, and I will take responsibility for my part of it, you advertise as if you're treating them for regular recruitment. And I take issue with that because the prayer in the writ petition is for appointment and compassionate appointment. So therefore, we have to confine ourselves to compassionate appointment. Advertisements is not part of compassionate appointment. Anyway, advertisements. What is this page now? 52 is correct. First advertisement. Now, my lords, at page 52 is the first such advertisement.
What's the date of that advertisement?
I beg your pardon?
What is the date of that advertisement?
30th of June 2006. Shortly after this document was signed.
No, but then the entire issue was raised by them earlier in a writ petition we just found.
Yes.
That writ petition, there was a direction to appoint in 6 months. In the appeal, intra-court appeal, there was a consensus recorded that yes, we will be doing it.
No,
now, in MAT 1362 of 2012, there is already a consensus. Though whatever happened prior to that is hardly relevant today.
Consensus, my lord, to consider.
So let's see, let's start from there. Whatever has happened prior thereto is hardly relevant today. There is a 1362 order of 13/3/2013. Then again, your board on 31/7/14 in fact recommended and sought permission from the Ministry of Defence to appoint them. So where is the question of making such a
difficulty arose because the CVC wrote to us saying that all the procedure you're following is illegal.
That's right. That's why the single judge said that they will supervise. They may participate in the recruitment, and if they want, they can supervise in a routine way and they can look into things.
They went in appeal. CVC went in appeal and said, we are not concerned with this kind of job. Please don't give us this.
Correct. So therefore, finally, it was decided that they need not be there, but they can review the situation periodically.
Since your lordship has an overall view of the matter, I don't need to trouble my lord further on this.
Yes.
The point is only this. Can that be compassionate appointment? If the writ petition is for compassionate appointment, is such appointment based on advertisements compassionate appointment?
Understood what you're trying to, you are what, if we have understood correctly, what you are arguing is, after decades, where is the question of a compassionate appointment? That is the first name of your submission. Second is that they were having means, they were not destitute.
That's right.
Which is apparent from that table which we have just seen. Under these circumstances, there is no scope for giving a compassionate appointment. There was no occasion for the single judge to direct. This is a sum and substance. But then, therefore, we ask you, we can go through everything you want. But the point is, how do we reconcile today's situation with the order passed in MAT 1362, crystallizing the right of the parties, inter-parties? Thereafter, you have acted on that. So how is there a scope today for
my submission? Yes. If I make a mistake, that mistake in law, if I make a mistake in fact, I must correct it.
Could have been, if you could have sought a review of the judgment passed by the division bench.
If I make a mistake in law, then no judgment, no order, nothing can come in the way. Article 16 is invoked here.
Very good.
May I just clarify my position on that?
Yes.
Compassionate appointment is not recruitment. That's my lord's own judgment. That's a recent judgment I've had the pleasure of reading. Compassionate appointment is not recruitment. It is an exception to the law of 14 and 16. Because otherwise, people are entitled to recruitment. By compassionate appointment, they are kept aside and certain number of people are taken in. Therefore, in order for the learned single judge to have directed me to consider something, he should have directed me to consider in accordance with law and not contrary to law. I've got a judgment which I'll show my laws on this issue. Consideration cannot take the matter from legality into illegality. My submission is to direct me to consider these people after so many years is an erroneous direction which should never have been passed. And having been passed is with great respect, I won't say void in law, but not enforceable in law. How can the learned single judge ask me to do something which the law does not permit? After so many years, can the learned single judge either direct by mandamus that I must appoint them, or can he direct me to consider them? By what law? So therefore, your lordship is right. There was a direction. But fortunately, in every case, there is a direction to consider. So when you say consider, It means consider in accordance with the law and not contrary to the law. That's my point out here. Now, if I can just make a couple of points for your Lordship's consideration. What are the points I would urge? First,
can we request you to take us through the decision of MAT 1362 of 2012 and the contempt proceeding arising therefrom? We would like to see these two. We have not gone through the records. We have just cursorily gone through the timeline and things.
The Lordship's acceptance of the facts is pretty amazing. In a cursory glance, my Lord has got the entire facts, so to speak. Anyway, 251.
250, volume 2, 250.
Volume 2, page 251.
Okay.
Hmm? It's a contempt order.
No, this is the first within 6 months, which is to be done. Since 17 appeal.
Just one moment.
251 appears to be correct from our book. MAT 1362 of 2012. Why have you not given him a copy of this?
They have given me the paging is different. Division bench. This is division bench.
Yeah, yes.
Very well.
First division.
This is an order of 13th March 2013. Please turn to the next page. Paragraph 2. Intra-court appeal has been preferred by the appellant, questioning the legality and judgment of the order passed by the single judge, thereby directing the authorities to conclude the process of recruitment of the writ petitioners to 153, subject to their eligibility within a period of 6 months. The learned advocate appearing on behalf of Garden Reach, who are the respondents number 154 to 158, submit that his clients are going to complete the process of consideration within a period of 6 months. The learned advocate appearing for the appellant, as well as the learned advocate appearing for the petitioners, respondents numbers 1 to 53, have agreed to the submission made on behalf of the respondents 154 to 158. Accordingly, in the opposite consensus arrived at by the learned advocates appearing for the parties, we direct the respondent number 154 to 158 to complete the process of consideration of the case of the writ petition with regard to their recruitment in accordance with law. Would your lordships just look at the last line for a minute again?
Yes, we have seen.
In accordance with law.
Yes.
We record that also agreed by the learned advocate appearing for the party that so far as possible, an officer of the Central Vigilance Committee will remain present at the process of consideration as aforesaid. Next one. In the event the officer of the Central Vigilance Committee fails to remain present, the authorities will be liberty to take periodical review of all processes. So, I want to emphasize, my lords, that at all stages, the court has not issued a mandamus to appoint. The court has always said you consider in accordance with law. Now, I have considered in accordance with law, and I am faced with the direction of the CBC and the Ministry of Defense. Both of them have categorically told me that don't appoint like this. Now, my lords, there's another order which my lords must also see. At 476.
The contempt order.
Yes. My lord said that. My lords, this is a contempt petition because according to the respondents, we had not done what we were supposed to do within a time frame.
Yes.
Now this This contempt order refers to the fact, when you see the portion in italics, this is what was said by the learned single judge in an independent petition, where he said, consider. Now, ultimately, at page 478, my lords have 478, yes. Third paragraph. In order to understand the controversy raised before us, whether there was intentional violation of the directions of the division bench of the alleged contemners, if at all the contents of Annexure 23 are to be read, and that would make it clear whether the authorities have complied with the directions or not. Under paragraph, up to paragraph 13, what was the exercise undertaken by the committee? Ascertain what exactly was to be done with reference to the candidates have been indicated. From para 14 onwards, reasons have been assigned why none of the candidates out of 109 listed candidates could be considered. It is relevant to reproduce the said para. I'll just pause for a moment. From a reading of this, it doesn't appear clear. What happened here was a report was ultimately made. We went into it, prepared a report, and showed to the court that none of these people were qualified. But I must point out against myself that this was based on a subsequent scheme framed in 2013. See, after that 2006 agreement between parties, ultimately the company went ahead in the year 2013 and actually framed the scheme. So by the time the division bench directed us to have a report prepared, the 2013 scheme was in operation. Based on the 2013 scheme, an in-depth inquiry was made, and the results are from paragraph 14 onwards. Out of the 109 letters sent through speed post, only 62 responses received by due date, that is 30th October 2014. 13 responses received after due date, 17 numbers got returned undelivered, and 17 applicants did not respond. Includes responses from Shri Pradeep Kumar Pathi, place, etc. The next page, kindly. On scrutiny of the 75 responses received, it is found that 9 candidates submitted the income certificate issued by the concerned revenue authority. Balance 68 respondents only represented in closing certificate issued by the local council or MLA, etc. And committee considered the same as not acceptable and accordingly recorded a decision on each of the representations thus made. A sample of such responses is placed in Annexure 9. Hence, the 66 cases of representations are not considered for further processing. Committee also checked the DIH register and found that 19 names out of 109 names were not appearing in the DIH register. Again, I pause. In the 2006 agreement, it was recorded that there would be a freeze on these people who could apply for compassion bond. So what this says is in the register, found 19 names out of the 109 applicants here are not appearing. So there is a DIH register based on the freezing done in 2006. So the authorities found that 19 out of 109 were not available in that register. The service files the concerned deceased employees of 10 applicants out of 109 are not found traceable even after repeated attempts. Committee found that 9 applicants only could finally provide the valid income certificate to ascertain their penury condition and also their relationship with the deceased employee being re-established. However, out of 9, only 3 names appeared in the DIH register, and the concerned employees' service rules of the deceased employees are also available. Copies of the 3 response 0, 8, 78, and 87 are enclosed. Candidates who submitted penury and income certificates are as follows, and these names are given here. But you will find, my lords, that person number 2 and the person at 24, the name is not in the DIH register, so we have no reason to believe that they were there in 2006 when the list was frozen. Similarly, on the next page, 53, 67, 75, their names are not available. So therefore, no reason to believe that they were part of the frozen number in 2006. Then para 20.
They are also petitioners here.
They are also petitioners here, yes. From paragraph 19, it is found that the names of only 1 candidate is appearing in the DI register are recorded within 1 year of the date of death of the employee. However, no application of the candidate is found in the corresponding service files. Also, the age of the candidate has crossed the maximum age limit specified in the prevailing recruitment rules in respect of operatives. C and D category of employees in GRSC dated so and so. Also, there are names of DIH registers who are not appearing in the pending list of 109. The DIH register is also found not authenticated by any signature. May I just pause again? I would like to emphasize that even the DIH register is not on there. Nobody has signed it. It's just a bunch of papers there. So what we have a number of people who are not in that list. We have a number of people who have not been able to supply any authenticated documents showing their penury certificate situation. Even in that list I gave my lords earlier, the majority of them are signed by some MLA or some other such functionary. Nobody has produced any proper receipt of any revenue authority or any other responsible authority to support their ages in that entire list. I'll come back to that in a moment's time. Then turn to para 21 kindly. The corresponding records filed of the deceased employee 10, even after repeated attempts, are not found traceable. Hence, the committee opined none of the applicants were found eligible as per the extent rules of the GRSC for compassionate employment. The reference documents to ascertain penury conditions on the basis of family income is annexed as annexure 11. On going through the above paragraphs from paragraph 14 onwards, it is clear that there is no deliberate or intentional act on the part of the committee to delay the process, but on account of verification of several factual doubts, it took some time to consider the matter in terms of directions of court. There is consideration of the applicant in accordance with law, as understood by the committee, as per the reports from paragraph 14 onwards. Since there is no intentional violation of the directions of the court, we are of the opinion that there cannot be any further action for contempt. Accordingly, proceeding the drop, it is open to the individuals to assail the decision of the committee if they so desire. Now, on this last paragraph, may I just emphasize one or two aspects. Fourth line, I'm sorry, the top. On going through the above paragraphs, it is clear that there is no deliberate intention. Lordships may ask a question, why have you not done it? But the reason is it took considerable period of time. 109 people's records had to be traced, and therefore it took a considerable period of time, and the division bench has accepted that as being a justified ground for there being no contempt against me. It took time. Then, my lords, line 5, there is consideration of the applications in accordance with law as understood by the committee. So the division bench has sanctified my action by saying that what I have done is in accordance with law. Now, there can be no directions for consider contrary to this. Once a learned division bench of this court has said you have done in accordance with law, that's the end of the matter. All that has happened is the last two lines. Accordingly, proceeding the drop, it is open to each individual to assail the decision of the committee if they so desire. There was no scope for a fresh writ petition. There was a scope only to see the conclusions of the report and to challenge the conclusions. What has happened here is they have bypassed this and they have filed a writ petition reiterating the whole thing all over again.
They have not challenged the decision of the committee.
No. That's my point.
Where is that decision?
What I read just now, plus you see at page 321. Is it 321?
Committee's decision.
Yes, this report that I read just now, this is the report of the committee. So they were given an opportunity to challenge that.
So that decision of the committee, what is the date of that decision? And where is it?
14th January 2015.
14 January
2015, Milords.
At page 825.
It's page number 302.
Oh, 302.
Volume 2, page 302.
14 January 2015.
My lords. Because it took us that much time to prepare a report. 825. Now, if your lordships turn to page 323 for a moment. It starts, my lord, from page 302, and then individual cases have been considered by the committee.
So in the writ petition, they did not challenge it.
No, that's my grievance. Okay, they should have challenged this, saying this is wrong. Please, my lord, my learned friend must bear in mind that my action has been sanctified by saying we've done it in accordance with law. Now, once that is done, then there's no scope for a rehearing or a repetition all over again. Now, turn Malos to page 323.
Yes. Yes, 323.
Manoj said that 323. Here's a case of a name Asit Saha, date of birth so and so, name of deceased employees Ajay Kumar Saha. The entire record is here. Now turn to page 325 kindly. Consider all aspects. It appears that the applicant has not satisfied the basic requirements. Considerable period has lapsed, and after such a long time, any appointment on compassionate grounds is impermissible. In spite of being asked, financial condition of the family has not been furnished. Applicant is sufficiently overaged. And similarly, down the line, cover them all. Now, I ask myself a question, Maloj. If the test for compassionate appointment, and that must be kept in mind because that is the repetition. I'll show Maloj the prayers in a moment. If that is the thing, then the learned single judge could not have gone beyond compassionate appointment to say that you have agreed earlier, you have not complied. After so many years, the appointment, right or wrong, cannot be called compassionate. That is what Supreme Court says, and I'll cite that. So therefore, my submission is that I was required to consider, I have considered. My consideration has been accepted by the division bench. They were asked to challenge the consideration. They have not challenged it. And they have come to court by a waiver de novo petition. And the court has granted relief based on a de novo position. Now, before I go to the learned single judge, your lordship must be shown one other thing. There was a report, my lord, of the CBC, which is at page 80. This is important because the learned single judge has, in 3/4 of his judgment, said that everything was done by the CBC. Because of the CBC, everything went wrong according to the learned single judge. So this document, Malot, is of importance. This document is of dated 6/11/2008. Can I read it, Your Lordship?
Page, please.
Oh, sorry, page 80. 80 of the convenience company. Of the convenience company. Yeah.
An office memorandum.
No, this is CBC office memorandum. That's right. Now, while I'm reading this, I'm cognizant of the fact that it is not binding. But the point I'm making is that if it comes to my notice that there has been something illegal, must I continue what I was doing despite being brought to my notice? The Commission has desired the Department of Defense Production may conduct immediate inquiry into the ongoing recruitments and take necessary corrective action. If allegations are established, all irregular motivated appointments should be quashed, further recruitment should be suspended, and fresh recruitment should be conducted after ensuring that proper recruitment rules and procedures are in place. For the fresh recruitment, a non-partisan arrangement should be instituted to ensure the desired integrity and fairness. Now, I will point out that the single judge, in more than 4 or 5 paragraphs of his judgment, has said, we have done what we have done because we relied on this. And there he says, you are wrong. And my submission is that this may not be binding upon me. But if it comes to my notice that there's something wrong, then I'm within my rights and I have my duty to also correct myself. And this was done also by the Ministry of Defense, which is my nodal agency. Now, when we talk about my correcting myself, I'm remiss in not pointing out to the court that there were 4 phases for this recruitment. 3 phases we completed. Then we got this notice from the CBC and we stopped. I mean, I'm saying this because the other side's contention is, okay, you have taken 3 phases. How can you discriminate? And my submission is, okay, there's no question of discrimination. If you are not entitled, the mere fact that I've done illegality earlier doesn't make your appointment legal. That is their defense. You have done 3 phases you have appointed. 1 phase you are not appointed. That's discrimination. And my submission, it can't be. I have corrected myself. I was doing something wrong. I was informed that it's wrong. And as soon as I was informed, I stopped the 4th phase. This is the CBC's document. Now, can I take you to page 81? My lords have 81 in hand. This is Ministry of Defense. The Central Vigilance Commission have brought dated 6 November 2008, forwarded a copy of source information pertaining to serious irregularities and corruption in recruitment of casual laborers in Garden Reach Shipbuilding and Engineering GRSC, Calcutta, with direction that immediate inquiries be conducted and necessary corrective action be taken and report be sent to them. The matter was taken up by the CVO, GRSC and CMD GRSC, and the commenced reports received from them have been examined and it has been decided with the approval of Secretary DP that an industry should be conducted through the BOB comprising of shares. We're not concerned with that. So apart from CVC, which is not binding, the direction of the Board of Department of Defense, that is binding on me. And pursuant to that, I have taken action. At page 84.
15 item 6, 85.
My lords have that? This is my letter dated 9th March 2009 with regard to the 4th phase. And turn to the next page, 85, paragraph 6. Read paragraph 6. Recruitment of SM4, 4th phase, the management has completed 3 phases of recruitment as per the understanding with the union. Please notice the word understanding. There is no policy, there is no scheme, not even a settlement. It's only an understanding with the union. The 4th phase of recruitment has been held in abeyance pending inquiry ordered by the government on the advice of the Central Vigilance Commission. The same will be reactivated based on the inquiry report. Advertisements.
Yeah. Thereafter, the CBC is saying no further recruitment.
That's it.
Yeah. Thereafter,
My lords have that now?
further.
Can I take you to page 90 for a moment? This is a letter from the Joint Secretary to the CVO. Please refer to your DO letter now so-and-so regarding irregularities in the recruitment of casual laborers of Garden Reach Shipbuilders. The ministry has already constituted a board of inquiry as, I'm sorry, I can't, as so-and-so. The matter, the BOD has recently submitted report, but it is observed that as an appointment, that has, I'm sorry, I can't read that. I don't know if your lordships can read it. All right, we need not trouble the court with that. Now, next page, kindly, page 91.
Type copy.
91. This, my lords, is the minutes of the meeting in the chambers of so-and-so regarding irregular appointments in CBRSA. Turn to page 92 kindly. No, the Ministry of Defense is also there, and also CBC is there, if you see on the first page itself. Now please see page 92, paragraph 2. On discussion with CMD, GRSC and joint and CVO, observed that there were no recruitment rules for recruitment of unskilled workers and in GRSC. Without laying down rules and procedures, recruitment were being done in GRSC. This state of affairs was not acceptable as it led to favoritism, misuse, and discretion and ad hocism. The Vigilance Commission advised CMD to frame the recruitment rules for all categories at the earliest in consonance with the guidelines instructions issued by DOPT and get the same approved from the competent authority. CMD GRSC assured that it will be done by February 2010. The Vigilance Commission further advised CMD GRSC that the appointments on compassionate grounds, i.e. death and harness category, should be done strictly in terms of the guidelines laid down by the DOPT. In case of any problems in implementing the existing instructions in the face of the High Court judgment, the ministry should be approached for necessary guidance. In no case should the existing guidelines in the government be violated. Then paragraph 6. VC further observed that the present practice of getting the dependents, the deceased employees certified from the union was highly improper. You see here what was happening, the union was certifying that they are entitled to this because on the date of that. There was no independent information available. So this report says okay, the action of the union certifying them as being eligible is totally wrong.
But all this is prior to the decision of MAT 1362.
Yes.
That decision is March 2013.
Yes.
Yes. That's right.
March 2013.
That's right.
Now, I don't know whether the learned judge was shown this or not shown this, but the point remains only one. I have done what I have done, and the learned judge has only asked me to consider in accordance with law. According to me, what I have done now is in accordance with law, so I'm not in breach of the order of the court.
Oh, but if they have not challenged it altogether, then
they have not challenged it. Anyway, since I'm on my legs, may I just point out two things. There are two challenges. One is that the 2006 understanding was the foundation for them to get their right. Learned single judge says you froze the names of people in that 2006. Therefore, they have an absolute right based on that to get appointment. My point is, first of all, they have come after 1 to 13 years. That can never be a valid. Assuming 2006 is valid, assuming it is binding. If you come after 1 to 13 years, that can never be considered to be compassionate appointment. Learned judge has failed to notice that. There are a couple of points, Manoj. I'd like your lordships to see the 3 advertisements also. They were all advertisements for appointment on casual basis. No, I'll show all. The first one, my lords, is at page 52. My lords, have that? Page 52, my lord. This is an advertisement of 30th of June 2006 for the first phase. Please notice the first thing, invites applicant. Yes. The highlight invites application for the post of casual laborer. So they have never been given a chance to appear for regular employment. Then please turn to the next page. No. 6A. Casual employment is purely temporary in nature and based on the requirements on any day-to-day basis. Now, if the learned single judge directs me to consider and appoint them, is there any material and report to indicate that on that day to which they were supposed to be appointed, there was a vacancy? I'll come to that. So therefore, in order for this advertisement to apply, the appointment must have been on a vacancy existing on a day-to-day basis at that time. It is this vacancy which has to be filled up.
There is a vacancy earmarked. How much? 5%, 10%, how much?
5%.
5%.
But what I'm driving at, my lords, is that there is nothing to show that there was a vacancy on that date.
And we have appointed more than 80%.
And I'm told, my lords, I'll come to that. Turn to the next page kindly, 55M. Preference will be given to the eligible dependents of the deceased GRSE employees of all units who died in harness, subject to merit being equal. Now, who has tested this? Has a learned single judge tested that these people had merit which was equal to A, B, or C in the permanent list? Without that, there can't be an appointment even under the 2006 scheme. This then takes away the rights of other people in the general category who are otherwise better suited or even equal. Now, the next advertisement is at page 59. The same two clauses are there at page 60 and 62.
Please come to clause R.
I beg your pardon?
On the next page.
What is R? 56 minutes.
Page 56.
My lords have that now? May I go further?
Clause R at page 56.
Yes, R, all right.
We have read M. You just showed us M. Regarding regarding merit.
Age and qualification may be relaxed in deserving case of dependence of the deceased employees who died in harness with the approval of the competent authority. But this would apply if there was a proper application immediately on the death of the deceased relative. This would have no application after 1 year or after 13 years. Now, please turn to the next advertisement, which is at page 59. This advertisement was 3/11/2006. I don't have that.
Yes.
Same to, now, first of all, casual. Again, this is casual.
There is any variance or it is in the same line?
Same lines.
Only numbers have been changed.
Yes, numbers have been changed, correct.
Numbers will change every time.
Yes. Now, the third advertisement is 16/3/2004 at page 66. Same thing, same consideration. Hmm? And the last one, my lords, the fourth phase, which we are concerned with here, is at page 73.
We have recruited.
Now, my lords, out here, I have several points. Because if they don't succeed under 2006, they can never succeed in a 2013 scheme. So let us test 2006 at its best. First of all, it is casual employment. So even they are not claiming permanent employment. They're claiming casual employment. Can there be a mandamus to appoint casuals? That's point number one. Point number two, my lords, the chart, as I've indicated earlier, shows that they came much after the decease of the relative concerned. Third thing is, this appointment, even under these advertisements, is only per need. If there is no need, I don't have to appoint them. The 2006 circular doesn't compel document does not compel me to appoint them. It's entirely as per need. Who has clarified that on this date, when the fourth circular was issued, there was need for this many people? Nobody. Then, my lords, the petition is dated 13/12/2011. The first petition that they filed is dated 13/12/2011. 2006 is the circular. Third recruitment is on 11/12/2007, and they have gone to the court on 13/12/2011. No, I'm sorry, first petition, I'm told the first petition was of 2009, I'm sorry.
Which were disposed of on this.
And it was disposed of on 13/12/2011. So even if you take 9, it is 3 years after the 2006 scheme. That can't be compassionate appointment.
Judges say 5%. We have appointed more than that, 155. Just What is the date of the fourth scheme?
Fourth, my lords, was the fourth advertisement was dated, my lord,
Page 73.
no, page 8/12/2007, and it remained in force till 14/12/2007.
So these are advertisements.
Yes.
But under which scheme?
They're saying that this is under the 2006 scheme, because there were 4 phases.
So there is a
And these are-
97 scheme, then there is a 2006 scheme, and there is a 2013 scheme.
98 was only an intention to create.
Whatever it is, that was the scheme, that was the policy.
They are relying on 2006.
Page 42.
They are relying on 2006.
Because they say there is a consensus, you have already agreed, the list was frozen, we are in that. Therefore, our right crystallizes with reference to 2006.
That's right.
What you are saying is whatever right we had considered to, we have considered, you did not come within the zone for these reasons.
I'll be honest again. When I say I have considered 2013, that whole document I show my lords with the.
Yes, that was under the 2013, not under 2006.
But as far as 2006 is concerned, if you come after 1 year or 13 years, you can't be covered in compassion appointment. So whether they go under 13 or 6, that makes no difference.
Speaking more for myself, I need some clarity on this. There are 2 things you are saying. One is that they have come late. The other is that you are saying there was no scheme for compassionate appointment. It was for casual appointment.
Always. But casual appointees were being given compassionate appointment. When the advertisement.
So in the process of appointing on casual basis, there was a percentage earmarked for those
5%.
Claiming on compassion.
Correct. Now my submission therefore is to take either scheme. Take the first scheme, you've come too late. Take the second scheme and the report shows you're not qualified.
No, qualification relaxation is provided.
Qualification relaxation, but if you don't have an income certificate, if you don't show.
For casual, why do you need an income certificate?
Compassionate, I need. I don't need for casual, I need for compassionate. And they're all claiming as compassionate appointees. So therefore, Manoj, break it up if I may. 2006, you don't come as compassionate appointment because you've come too late. 2013, you don't come because you don't qualify. The report which I have framed in place before the court demonstrates that they don't qualify.
Accepted by the DB.
And that's been accepted, as my learned friend points out, by the division bench when they said, okay, what we have done, our consideration was in accordance with law. So once that is done, there is no scope for the learned single judge to have gone behind that.
Non-road court has just said about 5%. 155.
155 in the first 3 schemes.
Yeah. So that kind of 5% quota was positive. You have taken away. The government is 5%.
5% is mentioned.
The Honorable Single Judge has taken into consideration the committee's decision of 14/1/2015.
Yes. Yes, consider
Is it
that.
there in the judgment?
I'll just tell you, I'm not sure. I'll just answer you there.
14/1/2015, was it considered by His Lordship?
I'll just.
The Honorable Single Judge.
2015. My learned friend says it was. When I come to that, may I show it to you? May I just finish what I want to say? So therefore, Manoj, my submission is that 2006, they don't qualify. 2013, they don't qualify. Now let's go to the learned single judge. And second thing is, when the 4th phase was advertised, I was told it is illegal, and I was told to stop it. Now the question is, they say, I don't care that you were told to stop it. They were part of the 2006 frozen bunch. Legal, illegal, you must give them the appointment. And I submit I'm not bound to do that. In fact, I cannot do that once I'm told to stop. Now CBC is not binding, but Ministry of Defense is binding. It's my nodal department. And when they tell me don't do it, I'm bound not to do it. So therefore, Manoj, 2006 doesn't apply. 2013 has been demonstrated as not being applicable. Now let us see the learned single judge. What is it? Very well. Manoj, my learned friend wants me to point out page 88, which shows you, in fact, the date of demise. Where's demise? Demise. It is a date of demise in this chart. Manoj, have that page 88, is it correct?
Yes, yes.
Page 88, chart at page 88.
Doctor.
Maybe not. Maybe not at 88.
661, I'm sorry.
661.
Page 661.
Manoj, have that chart? Now, in that chart, 1, 2, 3, 4, 5, 6th column is date of death. Now, in the first instance, date of death was in 2001. And the application, if I read correctly, is 2007.
My senior learned friend may not detain him because the applicant himself has expired out of tuberculosis.
That doesn't make a difference to my case.
He need not detain himself on that.
No,
the applicant himself got
the point is
expired due to tuberculosis.
Point is that all of them, not only this one gentleman. Manoj, may I make one request? Is it possible to have it tomorrow morning instead of the afternoon?
Do we have any?
This page income. More than half an hour. I've got case law to show you. Give me 1 hour maximum.
Fix it at 12.
Sorry?
Fix it at 12.
I reply on a different date then.
No. Can we not
My
finish it
senior
tomorrow?
learned friend can finish his argument.
I finish it tomorrow by 1 o'clock. Can we not take it in the afternoon?
No, we cannot. We have fixed matters at 2 p.m.
Very well.
There is a problem in the second.